What's up, guys? Good morning, everyone. What is it? 5:55 a.m. in LA. Waiting for things to get started here. Should be any minute. At first, when she was breaking, she said, this is Judge Paige Reese Whitaker on Friday, said 8:45, but then they had another discussion about, what's going to happen today. And she said, okay, 9 a.m. You guys have been so good. So, one thing that's interesting, if you look at the clips of Brian Steele talking about, this evidentiary hearing he wants to have with Jonathan Melnick, he was talking about how Melnick needs to needs to get a waiver, attorney-client privilege waiver. And yeah, I mean, it sounds like Melnick is being careful about saying anything in any kind of proffer before he gets something like that, because obviously he can talk about his motives and what he was doing, but if he gets into any discussions about Woody and his representation of Woody, he could get into attorney-client privilege issues. So he needs to get some kind of waiver from Woody. And remember, the whole reason for prosecutors wanting the ex parte in the beginning is because they were concerned. They didn't think that Jonathan Melnick was properly representing Woody's best interests. So it'll be interesting to see if Melnick is able to get a waiver from Woody that allows him to talk about what they talked about in there, because Steele said pretty strongly in June 10th when he called out Glanville on this meeting. It was like the first we'd heard about this ex parte. He said that he heard that Woody had confessed to the killing of Donovan Thomas. And Glanville was saying, you need to be real careful. And he said this to Weinstein and some other attorneys too, that they weren't, accurately conveying that they were misconstruing some of everything that happened in there. But he didn't really expand. He got pissed and jailed Steele on contempt for that. But when the transcript came out, it doesn't mention Donovan Thomas at all. It has the quote from Woody saying, I did these crimes. But I mean, there was no mention of Donovan Thomas's murder or his kill, anything like that. So Steele on Friday said, when he was talking about the need for Jonathan Melnick to testify, he was saying, he's heard that there was a discussion about Donovan Thomas that was off the record. So that either the court reporter wasn't in the room for, or she purposely didn't take down, which I'm like, wow, that's a really serious allegation. So he wants Melnick to testify about that today. We'll see if she allows it here. Law and Crime has the camera on. It's all the same pool that these people use. I think it's just a matter of who turns the feed on first on their channels, because ANF still doesn't have it. Atlanta 5 usually is pretty fast. Law and Crime is super on it, but they also put their logo right down there in the bottom when the other TV stations don't do that. Hot Sunday. I see you answer some questions. Yeah, I'll be happy to answer some questions. Mikey asked what time court starts today. It's supposed to start at 9, so any minute. And she's been starting on time, so I've got it. We've got it here, and I'll shut up as soon as they start, I promise. But yeah, I'm skeptical. I'm wondering if she's actually going to let Melnick testify. The fact that there was no proffer from him because he wouldn't talk to Steele beforehand almost kind of makes it so. I mean, is she going to be so curious? She wants to talk. Does she have some questions for him? But she was saying, I could issue my ruling on the mistrial before to see if you guys really need that. Because I think her logic on these ex partes, like she was saying to Max Shard on Friday, to her, it's not whether the allegations were actually true or whether Melnick is just going to get up there and admit, yeah, I was conspiring with the defense attorneys. It's whether the prosecutors had a legitimate concern when they called these ex partes. This is what the judge was saying. And I'm oh, here we go. You see the camera here. Got some movement there. Yeah, somebody said, I'm not sure if this is going to be allowed. If you just listen to the judge's tone and her skepticism with this whole thing, especially her tone with Brian Steele when he's talking about all this stuff, I wouldn't be surprised. Yeah, exactly. No mistrial, and Melnick isn't testifying. Exactly. She's not calling a mistrial, and he's not testifying. Because I wouldn't be. Okay, here we go.
All right, I hope everybody had a pleasant, if busy weekend. I'm sure y'all all worked just like I did. I know we have Mr. Melnick outside and he wants to put some things on the record. And we can do that first off. Is there anything anybody wants to address before that?
Okay, so he is testifying. Here we go.
Your Honor, after or before Mr. Melnick addresses the court, if the court would be so kind as to just apprise the parties of what it is that we will need to, if anything, address.
I mean,
as it relates to what he's putting on the record.
I don't really know. I think that he kind of mainly wants to make a record of what he perceives to have actually occurred. And I don't know that, as I think I mentioned on Friday, I'm not sure that it's particularly going to be relevant to any of the issues in the case, but I'm going to let him make a brief statement or proffer, and we'll go from there. And then the next issue after that I'd like for us to sort out is the representation made by Mr. Steele at the end of the day, Friday, that he has a good faith basis to believe that there may have been an unrecorded conversation at some point that included Ms. Hilton, Ms. Bumpus, and Mr. Copeland that may have resulted in some Brady material. So that'll be next up, and then we'll see after that. All right, so if somebody wants to let Mr. Melnick come on in.
And Your Honor, last thing,
Yeah.
I would just object to Mr. Melnick coming in offering anything that is not relevant to the trial itself,
Okay.
understanding what the court's ruled or
All right.
decided.
Thank you. Yeah, thank you. Ooh. Court with 500 screens in front of us. Mr. Melnick, if you want to come on up, and I understand that you want to make a proffer of what occurred, I guess, on June 6th and June 7th. Let me just say that I think it goes without saying that people can perceive the same thing in different ways, depending upon the perspective they're standing at the time. And I am going to permit you to make a brief proffer of what you believe happened. I do not think, based on what I have reviewed, that you were laboring under any conflict of interest. I don't even know that at this point in time, any of that is particularly relevant, but I can understand you wanting to put something on the record. I would like for you to stick to the facts to the extent you can, keep emotion out of it. And go ahead.
So, Judge, basically what it comes down to is after receiving the transcripts from the 2 ex parte hearings that took place, or ex parte meetings that took place between Judge Glanville and the district attorney's office, and then with Ms. Bumpus and Mr. Copeland in tow, the allegation has been made that I was somehow acting in conjunction with Mr. Steele and Mr. Shart and other members of the defense team in this case, which is categorically untrue. I am unfortunately in a difficult position as it relates to this issue, because what I would need to produce from a documentary standpoint to rebut these allegations are privileged communications between myself and Mr. Copeland. But my presence, so starting with June the 6th, I sent an email to Ms. Hilton, Ms. Love, Mr. Steele, and Mr. Shart stating that Mr. Copeland wanted to take the fifth, did not wish to testify. On the 7th, I was shown an order that was signed on June the 7th, stating that Mr. Copeland was being given transactional immunity. At no point, and I think what really bothers me is that at no point did anybody from the DA's office before that time, within any relevant time frame, reach out to me and just ask me if I was representing Kenneth Copeland for purposes of his testifying in this trial. Everybody in this room that has been involved in this case from the beginning has known that I was representing Kenneth Copeland.
All right, and I know because you had a case before me
with Mr. Copeland.
With Mr. Copeland that resolved in June of 2023.
That's
so
correct.
I know that as of that point, you were representing him.
Yes.
And then following the resolution of that case, he did not have any more pending charges.
He did
correct?
not. That's
Okay.
correct. Yeah.
All right, so that was a year ago.
So at a minimum, I feel it was incumbent on the district attorney's office to reach out to me just to ask that question. Now, as far as what communications took place between the DA's office and Mr. Copeland, I don't know exactly. But I do know that on June the 6th, he and I spoke, and he told me that he wished to assert his Fifth Amendment privilege. And so I sent that email. The transactional immunity order was granted on June the 7th, which I find the timing there to be, let's just say, ironic, in that apparently they were going to have Mr. Copeland testify without any grant of immunity, because it was the state's intended purpose to call him as a witness on June the 7th. And so I was here on June the 7th. I told the court what Mr. Copeland's intentions were. There was a lot of back and forth. Obviously, Mr. Copeland was taken into custody on June the 7th, and then everything that happened on June the 10th. I don't have to go over all
Yeah,
that.
I've read all of that.
Yes. So my purpose here today is to state on the record that absolutely, nothing that I said or did on Mr. Copeland's behalf was done in any conjunction or with any consultation, in cahoots or anything along those lines with Mr. Steele or Mr. Shart or anybody else in the defense team.
All right.
I was here doing what my client had expressed to me, what he wanted to do. And as I said, if it becomes a major issue, I have more than enough documentation to prove that.
Okay, I appreciate that.
Mhm.
It's not an issue at all to this court.
Okay.
All right, thank you.
All right. That's it.
That's it?
All right.
Okay, Mr. Steele, you had said to us on Friday afternoon that you had a good faith basis for believing that there may have been a conversation you believe during the June 10th, ex parte in chambers meeting at some point when Judge Glanville was not in the room, but between Ms. Bumpus, who was acting as counsel for the day for Mr. Copeland and Prosecutor Hilton. So can you give me what your basis is for that? Otherwise, we might just move on.
I also have a couple of questions, if it's okay,
All right.
for Mr. Melnick.
Oh, well, I think may have already walked out. I didn't realize that. I thought this was kind of to let him have a chance to clear the record. What are your questions going to be?
Just about the representations made about an email with a BCC and it was sent inadvertently. I believe that he'll say that that's not accurate. And then we sent your honorable court on Friday all of the emails. If you put them in order.
Yeah, okay. I mean, I've seen it. I think that's fine if you want to ask him that and clarify it. I don't think that Ms. Love made a representation that is in fact what happened. That was her theory because she couldn't figure out why Mr. Melnick was referring to her in the third person. But sure, you can ask him that.
Can I just ask you a couple more questions? Sure. And Your Honor, I'll move the admission of all those emails, and I have copies for them if that makes it easier, and we can mark them as an exhibit if that's what you want. They were already sent to your honorable court.
If you've got them now and can make them an exhibit, and I'm not sure exactly what courts, you would make them
Sure.
a defense exhibit.
Can I just step back for a second?
Sure.
And Your Honor, would the court be admitting those exhibits for any purpose as it relates to this trial?
No, not for the trial, just for whatever these ancillary proceedings are. I'm not sure what to call them, but motions. So it'll be, I guess, an exhibit to, we can call this a motions hearing. It's today, August 5th, 2024. Proffer by Mr. Melnick.
So, Mr. Melnick, have you looked at and reviewed all of the emails that you have given and the state has given on this topic?
Do you want me to be sworn? Do I need to be sworn for this? I don't believe I've been sworn.
Not for me. You're an officer of the court.
Yes, I have.
Hang on. Yes, Ms. Love.
You responded to what I was asking.
Okay.
I have reviewed the emails.
I have to mark these.
Uh-huh.
You give this to the state.
Yep.
You give that to the state. I'll just put him in date and time order.
Yep, I've reviewed them.
11:56. We have that. No, we'll go through once the judge is ready.
I'm ready whenever you are.
Okay, I thought you were not ready. All right, and thank you, Your Honor. Mr. Melnick, thank you for your time.
Sure.
What you said to this honorable court is that you represented Mr. Copeland in an unrelated case. Is that true?
That's correct.
All right. Was there any discussion with the Fulton County District Attorney's Office members that you represented Mr. Copeland for purposes of being a witness in this trial that's before the Honorable Judge Whitaker?
Yes.
Can you explain that to us?
It goes back to 2021. I met with Don Geary, who at the time was, I guess, in charge of the state's handling of this case. And he talked to me extensively about Mr. Copeland, Mr. Copeland's involvement with YSL, and the fact that the state wished to use him as a witness in this case.
And did you make it clear from your viewpoint that you were representing Mr. Copeland in this case, meaning the case that's on trial before Judge Whitaker?
Yes.
As a witness or as a potential co-defendant?
Yes.
Okay. And that the Honorable Court knows, I believe, but to your knowledge, who is Don Geary in 2021?
What he introduced himself. I mean, I knew Don for a long time, but what he said, he was special counsel for the Fulton County District Attorney's Office. He was basically hired almost like in an of counsel position, as I understand it.
And was he affiliated on working this case that's before Judge Whitaker
Yes.
on trial?
We talked about this case specifically.
At any time, I'm sorry.
And nothing else.
At any time, did you or any member of the District Attorney's Office in your presence ever say that you were not representing Mr. Copeland pursuant to a potential witness in this trial?
No.
Did you ever have conversations with Ms. Love, who is seated to your left,
Yes.
about representing Mr. Copeland as a witness in this trial?
Yes.
And when were those conversations?
March of 2023.
And was it clear from your standpoint, from your viewpoint, as the court said, people can observe things differently, but from your standpoint, was it clear that you made it known to the Fulton County District Attorney's Office that you were representing Mr. Copeland as a witness or potential witness in this trial?
Yes, it was.
All right. Did you do anything to separate yourself from that representation?
No.
All right. The Honorable Court stated a little while ago, and you left here so quickly, but that your representation ended of Mr. Copeland, I heard, in 2023 when you entered some sort of disposition. I don't remember what it was, before this Honorable Court. And when I say this Honorable Court, I'm talking about Judge Whitaker.
Sure. That's correct.
Did your representation end of Mr. Copeland as a witness in this case?
No.
Did you ever make that known to anybody?
No, I never did.
Did you actually do the opposite?
I was contacted by another member of the Fulton County District Attorney's Office in June of 2023.
And about
Yes,
what?
I'm sorry, about representing Mr. Copeland in this, as a witness in this case.
Were there any agreements between Mr. Copeland and yourself in the District Attorney's Office? Because you obviously got him not to be charged. That's a bad way of saying it, but you obviously did something, or someone did something that he's not charged in this case.
I would honestly say that may not have been due to anything that I did or said necessarily. That I think was an internal decision from the DA's office.
Okay. All right. Now, I'd like to show you what I marked, and I just want this for the record. And I marked it number 1, Mr. Williams. And can you announce it just so the court, and we're going to give all this to the court, what this is, if you recognize it.
Sure.
And then go to number 2, 3. But for people looking on, just announce it by the title, if you don't mind. If you don't recognize it, please say that as well.
Do I recognize this? This is an email I sent to Ms. Love, Ms. Hilton from the DA's office, yourself, and Mr. Shart, dated June the 6th, 2024 at 4:31 p.m. you want me to read it or?
Sure.
Says, good afternoon. All it has come to my attention that the Fulton County District Attorney's Office has questioned my client, Kenneth Copeland, without my knowledge or consent. Please be advised that my client does not wish to speak with any member of the Fulton County District Attorney's Office, nor any law enforcement officer from this point forward. My client will assert his privilege under the
Way, it's
I
way
am
too
going
fast
fast,
for the
I'm
court
sorry.
reporter to take down.
You with me? Law enforcement, nor any law enforcement officer from this point forward. My client will assert his privilege under the Fifth Amendment tomorrow and will not testify. Thank you, John Melnick.
Okay. On the 6th, and you made it clear, to your knowledge, was there any type of immunity agreement whatsoever in place? Use immunity, transactional immunity, any type of agreement?
There was no response from the district attorney's office to this email to me. So I was not aware of any immunity, any offer of immunity to Mr. Copeland at that time.
Did you personally know that if Mr. Copeland testified at this trial without some sort of protection, by protection, I mean whatever type of immunity, that he could be making statements that would incriminate himself?
Yes.
No statute of limitations ran, he could be charged?
So I can't say that with absolute.
Okay, well, we're dealing with a bunch of lawyers, so I think Mr. Melnick can handle it. I'm going to overrule that.
I can't say with absolute certainty that I investigated it to the point where I would know whether the statute of limitations would have run or not.
About federal crimes for gun offenses?
No, as far as I know, again, I didn't do extensive research into it, but it's my understanding that it would not have run in terms of the federal statute. And Mr. Copeland, of course, has been charged previously and convicted in U.S. District Court. So once the feds have their eyes on you, they have their eyes on you.
And how about as a co-defendant in this case being indicted later? And the statute of limitations barred to that?
I don't know.
Okay, that's fine.
I don't know with absolute certainty.
Okay. Were you concerned that if he testified, when you wrote this email, the one you just announced as Mr. Williams #1, that he could be facing criminal liability?
I absolutely was.
All right. Is that the reason you wrote that email?
Among other things, but that is one reason why I wrote the email.
Was there anything in your mind at the time of sending it that was suspicious or clandestine or by CCing the Honorable Maxwell Shard or myself on that email?
Not at all. I thought everybody had a right to know.
Okay. And everybody being?
Everybody from the prosecution and the defense team.
Okay. All right. Your Honor, move for the admission of Mr. Williams #1 for purposes of this hearing.
It's admitted.
Can I just get clarification as to which of the emails we don't have the number is defendant Williams #1?
Can you
Yeah.
clarify?
June 6, 2024, 4:31 p.m. to yourself, Ms. Hilton, Mr. Steele, Mr. Shaw.
Does it have the response at 4:57:05 from Ms. Hilton, or is it the one without response?
I don't remember seeing a response.
Okay.
So is there a response on there
There's not a
on
response.
Williams 1?
There will be, Your Honor.
Okay,
Not
so
on Mr.
that
Williams
has
one.
been, for purposes of the record, the one that does not have the response on it.
Okay. Okay, so here's the response.
But, well,
Is it a part of Williams 1?
No, it's not.
Okay, so I assume Mr. Steele might ask you about the next one. Go ahead.
and that is, I'd like to show you what's in front of you, Mr. Williams, exhibit #2 for purposes of today's hearing, okay?
Mhm. Yes.
Tell us, take your time to look at it. Tell us if you can identify it, if it's true and accurate for what it appears.
I hope this is from Miss, I think exclusively from Miss Hilton to me.
But do you recognize it?
I do, I
Is
recognize
that
it.
accurate?
Yes, it is. Yeah.
Okay. Your Honor, I move for purposes of this hearing, Mr. Williams #2, after you identify it so everyone knows what you're looking for.
June 6, 2024, 4:57 p.m. I hope good as addressed to me. Good afternoon. I hope all is well. In our conversations with Mr. Copeland, he advised that you were not his attorney and he had not spoken with you. However, if you are asserting that you are his attorney, we will cease communication, but your client is under subpoena and is expected to be here at 8:30 a.m. It is our understanding that your client does not have transportation, so we're planning to pick him up. So please make sure that he is present so we do not have to take any further action if he fails to appear for his subpoena. Thank you and have a great evening. And then it's from Ms. Fulton.
And did you respond to that email? And if yes, is it on Mr. Williams #2? And what does it say in time and date? If you don't-
It is. I did respond. It's dated June 6th at 5:47 p.m., again with CCs to everybody in the case. I have been Mr. Copeland's attorney. He tells me that he repeatedly told you that told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love.
Slow down.
I spoke with Ms. Love early in the process around the time jury selection was beginning. I have a plea with Judge Carnicel tomorrow at 9 o'clock, and I will come to the courtroom as soon as I am done.
Is everything that you responded about being Mr. Copeland's lawyer for purposes of this case true?
Yes.
And the court already admitted number 2. If you could go to number 3.
Well, no, I haven't.
Oh, I'm sorry. I moved for the admission of Mr. Williams, number 2.
It's admitted, and that one contains both Ms. Hilton's response and then Mr. Melnick's response back that he just read. Is that correct?
Yes.
Okay, that's admitted.
Okay. This is a repeat, some withdrawing. Okay. Okay, if we go to Mr. Williams, number 3, can you take a look at this and tell us whether you recognize it? And if yes, what is it?
It's
Your Honor, if we could just have what that is, and you don't have numbers on it, if I could just have in the court what it is that you're even tendering.
I don't know. I don't know how many things you got handed, but Mr. Melnick's about to describe it.
It's dated June 7th, 2024, 11:52 a.m. It's from me to Ms. Hilton and Ms. Love. The first sentence says, "Here is a communication between myself and Ms. Love, which pertains directly to the YSL case." And it's a forwarded message from a number of people, including myself and your case manager, Sheila Rosser, dated March the 3rd of 2023. And it's from Ms. Love, stating, "Good morning, Ms. Rosser. State asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, not by the court in person." And that is in reference to 2 bond orders, I believe, that I had prepared and presented to the court in reference to Mr. Copeland's case that was pending before you in 2023. That is an email dated Thursday, March 2nd, 2023 at 4:42 p.m. And this is just a chain of emails related to the bond order for Mr. Copeland's case in 2023.
All right, and you're forwarding that in June of 2024 to say, see, you knew at some point it
Yes.
was representing him. Okay.
That's correct, Judge.
Is that document, is defendant Williams 3 a 3-page document, or just the one portion of the chain that you just?
So is this is a continuation of 3? Okay. There's more to it, Ms. Love.
Is it a 3-page
It
document?
appears to be, I think it appears to be a 3-page document, yes.
Yes, yes. Okay.
Do you need me to, I don't need to read all of this.
No, I don't think so.
I move for the admission of Mr. Williams, number 3, for purpose of today's hearing.
It's admitted.
Why did you, Mr. Melnick, why did you send this to the district attorney's office on June 7th, 2024, 11:52 a.m.?
Because of what they claim to be the confusion as to whether or not I was representing Mr. Copeland for purposes of his being a witness in this case. I think these emails demonstrate that I did in fact represent him and that they knew I represented him.
And were there conversations that you represented Mr. Copeland for the witness in the YSL case during that time?
Yes, there were.
And who did you speak with?
Ms. Love?
Okay. And you're responding to Mr. Williams, number 2, that's already in evidence?
Yes.
All right, Your Honor, I move for the admission of Mr. Williams, number 3. It is a 3-page document.
It's admitted.
And I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us, and I'm going to mark this as Mr. Williams, number 4. Can you take a look at this and tell us if you recognize this?
I do.
What is it? Okay. And what is that?
It's an email that I also sent on June the 7th, 2024 at 11:54 a.m. To Ms. Hilton and Ms. Love, referencing another communication I had from the district attorney's office. It was a forwarded message from Peachtree Offices, which is an executive office company that answers my phone for me, where I got a message from Peter Herzog asking me to contact him in reference to Kenneth Copeland. So it's a forwarded message from June the 27th of 2023 that I then forwarded to Ms. Fulton and Ms. Love, demonstrating that they should have just communicated with me about Copeland before questioning him.
And go ahead. I'm sorry.
And before we got into all this.
And who is Peter? And I'm going to spell the last name, okay?
Yeah.
Herzog. Who is that person to your knowledge?
I believe his last name is misspelled there. I think it's Herzog, but Peter Herzog is the assistant DA in the Fulton DA's office.
And Mr. Williams, what's marked as number 4 is sent for that message on June 27, 2023, about 3 months after the March 1, 2023
Yes,
correspondence with Ms. Love about Mr. Copeland.
that's correct.
Now, if your representation of Mr. Copeland had in fact ended when you disposed of the case before the Honorable Judge Whitaker, by that time, do you remember? Did it end?
So my case with Judge Whitaker, is that what you're
Yes.
asking me about?
Yes.
Yeah, I believe it had, but honestly, I haven't gone back and checked
If
it.
y'all have the case number, I can look it up and let you know the disposition date.
I don't have it.
Happy to do that. Nobody has it. It was a 22 SC case, but that's all I know. It's fine. I can probably pull it up some other way. Y'all go ahead.
Okay. And you forward this, you said why? This
To-
message.
To reiterate the fact that the Fulton DA's office knew and should have known that I was representing Mr. Copeland for purposes of his testimony in the YSL trial. Mr. Herzog was never involved in the case before Judge Whitaker. I'd never spoken with him about anything related to the case in front of Judge Whitaker. The only attorneys that I ever spoke with about the actual disposition of the case with Judge Whitaker was Abigail Potter, Abby Potter from the DA's office, and Mr. Abadi. And the only reason Mr. Abadi was involved with it, that's Adam Abadi from the Fulton DA's office, was because he was concerned about Mr. Copeland's testimony in the YSL trial.
And obviously Ms. Love, because she.
And Ms. Bond order. Yes, right. And
Same
Ms. Love with
reason.
the bond order. That's correct.
Now, I'd like to show you Mr. Williams, number 5. Oh,
Can
Your
I-
Honor, I
can I-
move for the admission of Mr. Williams, number 4.
It's admitted, and for purposes of the record, the case before me where Mr. Melnick represented Mr. Copeland is 22 SC 182134, and the final disposition was actually on June 29th of 2023.
And is the number 4 a one-page document, or are there any more?
It's a one-page document.
Okay, I'm showing you Mr. Williams, number 5. Tell us if you remember that, look at it.
I do.
Okay, and is it accurate?
It is.
Can you describe, like you've been doing, the date and time, what it is, what it purports to be?
Stated June the 7th of 2024. It's to Ms. Love and Ms. Hilton from me. And it is in response to an email that I received. I'm sorry.
That's okay. You can look at the documents, multiple.
Yeah. Okay. So this is a part of the same chain of documents where I was referencing the fact that Ms. Love certainly knew that I was representing Mr. Copeland. She and I talked extensively about Mr. Copeland, and she had told me that she wished to use Mr. Copeland as a witness in this case. Obviously, by the time we were having these communications in March of 2023, the case had long since been indicted, and Mr. Copeland was not charged as a party on the indictment of this case. So this is a continuation of the same emails going back to March 2nd and March 3rd of 2023, where we're referencing the bond orders. These emails actually go back to March the 1st of 2023, where Ms. Love is discussing whether or not Mr. Copeland should be subject to a curfew as part of his bond order. There are, I seem to remember, other communications in which Ms. Love references the fact that she's concerned about Mr. Copeland's safety and the like. And so The last part of this email, which is at the top of the first page, is where Ms. Love questions whether my concern is for Mr. Copeland or Mr. Steele and Mr. Shart's client, neither of whom I've ever met or have any relationship with whatsoever. And then I responded to that.
Did I ever do anything untoward to affect your representation of your client, Mr. Copeland?
Absolutely not.
Did Mr. Shard do anything?
No.
Did anybody come to you, at you, about your representation, Mr. Copeland, in this case?
What Mr. Copeland did on June 7th of 2024, where he asserted his Fifth Amendment privilege, was entirely his decision. I was there just as his mouthpiece, as a lawyer, as his advocate for purposes of him asserting his Fifth Amendment privilege. Other than that, I have absolutely no agenda in this case whatsoever.
When Ms. Love wrote on a motion, ex parte motion for the former judge, the recused Judge Glanville,
Yeah, I would
grant
object
your
to
client.
the introduction through this witness or the posing to this witness of any question about a motion that I wrote, given that the witness cannot testify confidently about anything that I specifically wrote or what I.
All right, well, I don't know yet what the end of the question is going to be, so I'll hold your objection until I hear the question.
And it's in the record. Already, Your Honor, I could get another copy though. Ms. Love wrote in that motion seeking use immunity under 25-5-507 for Mr. Copeland.
Yes.
That Mr. Copeland on Thursday, June 6, 2024, had some sort of interaction or dealings with members of the defense team. To your knowledge, is that true?
I have no knowledge of that.
All right.
Do you want to admit, or did you want to tender for admission Williams 5?
I do. Yes.
All right, that's admitted.
Thank you, Your Honor.
And Williams 5 is what?
Okay, Mr. Melnick, I don't have any other
Hang on. What are
questions.
you asking?
for
Hang on,
you.
hang on, Mr. Steele. What are you asking?
Just-
What it is?
Which one is it? Yes.
It's
Just
the last
part of
one they
one page?
discussed that, I don't know how many pages it is. I don't have any of it in front of me, but it's the last one they discussed that has the email from you asking who Mr. Melnick is most concerned about or something like that. And then Mr. Melnick's rather peppery response back.
Okay, so it's just, could the court ask for clarification, just one page or?
I don't know. 4 pages.
Mr. Melnick, were there any BCC? You know what a BCC is?
Yes.
Okay, I apologize for asking.
Yeah.
Were there any-
We're all old enough to know that that
Right.
means blind carbon copy. A whole lot of people don't know that anymore since we don't use carbon copies, but that's where somebody can see it, but the recipients who are CC don't know.
Yes, I did not blind
Mhm.
copy anybody on that last email. I just sent it to Ms. Hilton and stuff.
Any I apologize.
Yeah.
Any allegation that there was some sort of teamwork or conspiracy against the state of Georgia and against your client, Mr. Copeland, is that true at all?
It is categorically untrue.
All right. I want to thank you so much. I don't have any other questions.
Ms. Love, do you have questions of Mr. Melnick? Hang on just a second.
Just briefly.
Okay, hang on. You have questions too? All right, I'll let Mr. Sharp go.
And those are the court's copies.
Okay.
Mr. Melnick, if you're more comfortable taking the witness stand, that's fine, but, okay.
Mr. Melnick, good morning.
Good morning.
You, as part of your representation of Mr. Copeland, as part of your representation of Mr. Copeland, yes, sir. Did you also make it known, did you make your representation known to the defense counsel in this case, specifically myself and Mr. Steele?
I did. Yeah.
Okay. In your dealings with the defense in this case, have myself or Mr. Steele ever gone behind your representation, to your knowledge, and attempted to speak to Mr. Copeland without your knowledge and understanding?
I have no knowledge of that. I'm not aware of any time that would have happened.
Since you were alerted about the state speaking to Mr. Copeland, have you read the transcripts from the ex parte communications?
I have mostly read them. I will be honest and say I haven't read the whole thing.
Okay. Have you become aware that Mr. Copeland was speaking to the state in the week leading up to June 7th, 2024?
Yes.
Okay. Have you become aware that Mr. Copeland was in the actual courthouse speaking to the state on that week?
I became aware of that on either June 6th or June 7th.
Did you know anything about that as it was happening?
I did not.
Before you reached out to the state via those emails that have been introduced, did the state ever tell you that they were communicating with your client?
No.
How did you initially learn that the state was communicating with your client?
Are you referencing the week leading up to June 7th of 2024?
Yes, let me ask in a more precise manner.
Mhm.
Did you become aware on Thursday, June 6, 2024, that the state had been speaking to your client that week?
Yes.
And did you become aware that the state intended to call your client to the stand on the next day, that Friday?
Yes.
Okay. Did you, and how did you find out about the state's plans to call your witness to the stand?
I believe you called me.
Could you say it again?
You called me.
You being
Yes.
Max Sharp?
Yes.
Okay. And I called you on the telephone?
Yes.
Okay. In that conversation, did I ever ask you to do anything on behalf of myself or Mr. Steele or our clients?
Absolutely not.
Did I ever ask you to stop Mr. Copeland from testifying?
Absolutely not.
As a lawyer, is it appropriate to contact another lawyer about their client?
Objection, Your Honor, as to this witness being qualified to speak about what are in the ethics.
I would hope that every lawyer in the state of Georgia is qualified to speak on what we're expected to do under our code of ethics. I'm going to overrule that.
Would you repeat the question, please?
In your experience as a lawyer, is it appropriate for another lawyer to contact you about matters concerning your client?
That's Law School 101.
And is that what I did on Thursday, June 6, 2024?
Yes.
Mr. Melnick, before you got in, well, your testimony is you were involved representing Mr. Copeland
Yes.
throughout this entire period, correct?
Mhm.
Before you emailed the district attorney's office about their communications with your client that you were unaware of, to your knowledge, had Mr. Copeland been granted any sort of immunity or legal protections for his testimony?
To my knowledge, no.
Okay, after you contacted this district attorney's office and actively communicated with them about your client, what protections was Mr. Copeland granted?
Use immunity.
I have nothing further. Thank
All
you.
right. Any other defense attorney with questions for Mr. Melnick? All right, hearing no other. Go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, I'm just gonna be a little bit brief and I'm gonna clarify some things. Is defendants Williams exhibit? Yes, Mr. Hart.
Or speak just more loudly.
Fair.
Or come around and, yeah,
I'll take
Okay.
the stand.
okay.
No, I just can't get these.
You can leave them there.
Okay.
It's okay.
Does somebody have a copy of those exhibits for the court?
Judge, I'll give to the court the ones that he has admitted, and I'll just go ahead and use the ones that I have copies.
Okay, thank you. Just pull that mic down towards you and make sure the green is on. Mr. Melnick, there
Oh.
should be some button somewhere.
You see where it is?
Green's green.
I don't actually see it. It sounds to me like it's on.
Yeah, sounds like it's on.
Yeah.
All right, go ahead, Ms. Love.
Thank you, Judge. Mr. Melnick, and Your Honor, I'm going to use, unless the court instructs me otherwise, I'm going to use the copies that I was given, that I've marked as defendants the way that they've indicated they should be marked exhibits.
Okay.
Okay. Mr. Melnick, I'm showing you what is the copy of Defendant's Exhibit 1
Yes.
that was given to the state and to the court. Is this an exact copy of Defendant's Exhibit 1 that I'm showing you?
I believe so. I mean, I haven't printed them up. I don't know if there was another email that was.
Y'all are welcome to just use these if you want. That doesn't need to be an issue. I mean, they were handed to you, Ms. Love, by Mr. Steele, right?
Yes, Your Honor.
All right, then they ought to be exact copies.
May I refer to them?
Just a second. Mr. Harvey, yes, can you not hear? Oh, me? Okay, sorry. I was just saying, I'm sure that the copies are the same, but if she wants to use the admitted copies, she can. I'll trade you. How about that?
Yes.
Just make sure you get the admitted copies to the court reporter when we're finished with this.
Yes.
Thank you.
So showing you what has been admitted as Defendant Williams Exhibit number 1.
Yes.
Looking at Defendant Williams Exhibit number 1, is that an extraction? In other words, is that a portion of an email cut out and isolated from a larger email?
I don't believe so.
Then I'm going to show you Defendant Your Honor, I just may need the portions that I gave to the court because I don't see.
All right, here you go.
Yep. Thank you. All right. All right. Showing you what I will mark as State's Exhibit 1, copy of Defendant Williams Exhibit 1, Melnick proffer. And I was provided this by Mr. Williams, Your Honor.
By Mr. Steele.
Yes. Could you look at what I've now labeled as State's Exhibit 1 and compare it to what has been admitted as Defendant's Exhibit 1 and tell me whether or not those two documents, State's Exhibit 1, just for the purposes of the record, is a 1-page document. Could you tell me whether these two documents contain the content from the same email?
So the content appears to be the same, other than the fact that on the one that you just marked, there what appears to be the seal from the Fulton County, the Atlanta Judicial Circuit.
And in fact, the one that I've marked as State's Exhibit 1 is the actual email that Mr. Steele would have had access to, correct? It's the it's a portion of the actual email chain, given that it has that seal on it.
Very often, if I'm sending an email, I'll just pick up from the last email that I sent to or from that individual. So that may well be, there may have been a prior email, but I mean, if it was between you and I don't remember exactly when it was.
I'm showing you what has, I believe, been marked as defendant Williams exhibit number 2. Let's see if those two match. Give me 1 second, okay? Defendant Williams exhibit 2. So you'd agree with me that defendant Williams exhibit 2 is in fact the top portion of the email that I have labeled and tendered as state's exhibit, or not yet tendered, but labeled as state's exhibit 1.
Yes, that's correct.
Your Honor, the state tenders state's exhibit 1 just as evidence.
All right,
All right. Now,
admitted.
thank you, Judge. So looking at defendant Williams exhibit 2 and state's exhibit 1, are you able now to say with any more clarity that defendant Williams exhibit 1 is a document, a piece of paper where a portion of the email chain that is contained within defendant Williams 2 and state's exhibit 1 has been extracted and pasted onto a piece of paper?
So I can't speak for how Mr. Steele printed this up. I wasn't there in his office when he did that, or whenever somebody in his office did that. You are correct that what has been marked here as Mr. Williams exhibit number 2 is part of a chain of communications between myself, yourself, Ms. Hilton, Mr. Steele, and Mr. Shart. Looks like there's a CC to Antonio Long as well. Yeah, so but these emails were sent after the state's exhibit 1, which is also Mr. Williams exhibit number 1. These emails dated, so you can see here, Ms. Love, this is dated June 6, 2024, 5:47 p.m. Yeah, this is dated June 6, 2024, 4:31 p.m. Right. So this is just part of the same line of communications that we were having, where I said, Mr. Copeland doesn't want to plead, doesn't want to testify, wants to take the fifth. Ms. Hilton responds, and then I respond to her response. And in her response, this is where you get your insignia for the Atlanta Judicial Circuit.
Okay, so let me be clearer. The exhibit that is labeled defendant Williams exhibit 1, did you ever forward that separately to Mr. Steele or Mr. Sharp?
I think I just forwarded. I mean, I wouldn't have had to because they got the emails. Right.
Okay.
So they got this email initially.
All right, y'all, when y'all are saying this email, we have no idea
I got
what you mean. Can you refer to the exhibit numbers?
They got Mr. Williams email number 1, exhibit number 1, which is the first email from June 6th at roughly 4:30 p.m. Then there was a response from Ms. Hilton, June 6th, 4:57 p.m.
And that's marked Williams 2.
Williams 2, thank you. And then I respond to that June 6th, 5:47 p.m.
Okay, so
And that's also on Williams
2,
right?
yes.
Yeah, okay.
so as it pertains to my original question, defendant Williams exhibit 1 was never a communication that you sent separate from the emails that are contained in defendant Williams 2 and state's exhibit 1. Is that wrong or right?
That is wrong.
Okay, so you sent, without forwarding the rest of what is labeled as defendant Williams 2 and state's exhibit 1, you sent an email that contained only the document that is labeled defendant's exhibit 1 to Mr. Sharp, Mr. Steele, Ms. Hilton, and myself.
I sent it on June the 6th at 4:30.
Right. And do you also see June 6th at 4:31 p.m.? And when you say 4:30, you do mean 4:31 p.m.?
Yes.
Do you also see June 6th, 2024 at 4:31 p.m. on the email State's Exhibit 1?
Yes.
And in fact, the email State's Exhibit 1 is at the bottom meaning it came before
Yes.
the emails that were defendant Williams Exhibit 2.
That is correct.
Okay. And so given that State's Exhibit 1 looks as it does, are you saying that the email that is defendant Williams 1 is the entirety and not a part of any other email chain that you sent?
This email was the first email sent. Okay, so when I say this email, I'm referring to Mr. Williams Exhibit number 1.
Okay.
Was the first email sent on June the 6th of 2024.
Okay.
That is the first email. Mr. Williams Exhibit number 2 is the continuation of that chain of emails in which Ms. Hilton responded to me, and then I responded to everybody else, including yourself.
Thank you for clearing that.
Mhm.
Your Honor, I'm going to give back to the court's copies of the emails.
Okay.
Thank you. And I apologize, they're not.
That's
Okay. You were asked, Mr. Melnick, you were asked by Mr. Sharp, how did you become aware that the state was talking to Mr. Copeland?
okay. Let's try to figure out where that squelch is coming from.
Might
and
be from
maybe-
me. I may have been too close.
Okay.
to
Where's
myself.
State's one, Miss Love?
And Your Honor,
If
if the
you've
court
got-
didn't, I tendered.
Yeah, you did. It's submitted. Thank you.
Did we clear up the squelch? Is it gone? Okay.
It seems to be.
Is it the court's mic? Okay. I'll step away from it so that I'm not echoing. Mr. Melnick, do you remember Mr. Shard asking you, how did you become aware that the state was talking to Mr. Copeland?
Yes.
And did you understand that question to me in 2024?
Leading up to June 7th of 2024, yes.
Did you answer how you became aware that the state was talking to Mr. Copeland?
I did,
How did you become aware?
because Mr. Shar told me.
Okay. And when Mr. Sharp called you, was that the first time that you were aware that the state had been talking to Mr. Copeland?
Since, I was aware of an interview that took place with, I think it was Investigator Viverito. I don't remember the date of that interview, but it was during a time when I was representing Mr. Copeland. But other than that particular communication, that was the first time I became aware of any direct communication between the district attorney's office and Mr. Copeland.
And when you speak of the interview by Investigator Viverito, was that while she was with the DA's office or while she was with the Atlanta Police Department?
I do not know.
And was that interview one that you have seen or have knowledge as a part of the discovery in this case, or something different?
I have knowledge of it. I've never seen the interview. I know that it exists.
And was that interview a formal interview while he was in custody at the jail?
Yes, as I recall. I mean, I haven't seen the interview, but I believe he was in custody at the time.
And did you give permission for that interview? I'm gonna turn this off.
Just speak loudly.
Did you give permission for that interview, or did Mr. Copeland reach out to Investigator Viverito to talk to her?
I have no idea. I did not give permission for that interview. I do not know if Copeland reached out to her or not.
And had you been paid by Mr. Copeland or retained by Mr. Copeland to represent him on criminal charges at that time?
Yes,
And was that prior to March of 2023 that this interview took place?
yes.
Do you recall at any time representing a member of the district attorney's office in 2023 that Mr. Copeland had not paid you for your services?
No.
Do you recall telling a member of the district attorney's office that you were not representing Mr. Copeland on his criminal charges because he had not paid you? I'm just asking if you remember. If you don't, that's fine.
I don't.
Okay.
No, represented him in his criminal charges to the end.
We understand.
Yeah.
And when Mr. Sharp called you, what was it? What did he say to you exactly?
He said that Mr. Copeland was being called as a witness the next day, June the 7th of 2024.
So at what point how did he tell you that the state had been talking to you?
During the course of that conversation,
What did he tell you exactly?
he just said that the state's been speaking to Mr. Copeland.
How many times have you spoken with Kenneth Copeland between the time that Mr. Sharp called you and the time that you resolved his criminal matter before?
How many times did I speak with him between June of 23 and May of June of 24? I mean, I can't give you an exact number, but Mr. Copeland has always been in communication with me.
Did you speak with him more than one time?
Yes.
And during your communication with him, did he always have access to your phone?
Always.
Did he appear to always be aware that he could reach out to you at any time?
This is something where we're going to have to, I don't feel comfortable.
I can stop and pull that question all the way back.
All right.
And the court can decide if the next question is privileged. Did you assure Mr. Copeland?
I'm not going to talk about anything I said to Mr. Copeland. Period. I'm not going to talk about anything that I said to Mr. Copeland.
Okay. Based on how you have already testified, is it safe to say Mr. Copeland didn't reach out to you and say to you?
I'm not going to talk about any communication I had with Mr. Copeland.
Do you have any idea why it would be Mr. Sharp who first alerted you that the state was talking to Mr. Copeland?
No.
And are you aware of any communications Mr. Copeland made to state as it pertains to your representation of him after his criminal case was resolved?
I'm not.
Do you recall, you indicated that you spoke with Mr. Abadi, the district attorney's office, regarding Mr. Copeland as a witness in the case that we are in trial on now.
Yes.
Do you recall telling Mr. Abadi that you were not representing Mr. Copeland beyond the criminal case?
No.
Was the time or times that you spoke with Mr. Abadi in the context of resolving or getting a bond for Mr. Copeland's criminal charge?
It was primarily with regard to the bond and the underlying criminal charges. I don't believe Mr. Abadi has much, if any, involvement in this case.
What is your recollection of what it was that you said to Mr. Abadi or anyone else regarding your representation of Kenneth Copeland beyond his criminal charges?
I don't really recall having, other than the fact that, you know, he's talked to me and I've talked to the state, I don't recall having in-depth conversations about it. Y'all were still in the middle of jury selection. It wasn't much of an issue.
Understanding you don't recall having in-depth conversations about it, what is it that you recall telling Mr. Abadi or any other member of the state about your representation of Kenneth Copeland beyond his criminal charges?
I don't really have any independent recollection of anything specific.
How are you then able to say that you spoke with members of the state and told them that you represented Kenneth Copeland in his capacity as a witness in this trial?
Because I had specific conversations with Don Geary about this case and about Mr. Geary's desire to use Mr. Copeland as a witness.
Am I correct that that was pre-indictment?
Yes.
And am I correct that that was at a time when there was at least a prospect that Mr. Copeland would be a defendant and not only a witness?
That's correct.
So apart from the conversation you had with Don Geary pre-indictment, where there was a prospect that Mr. Copeland would be on the indictment, Do you have any recollection of conversations that you've had with members of the district attorney's office regarding your representation of Kenneth Copeland as a witness in the current case 22 SC 18357?
Miss,
Regarding your representation of Kenneth Copeland as a witness only in the current case 22 SC 18357.
just that I'm representing him.
And you recall specifically saying to some member of the DA's office, apart from the criminal charges that you helped resolve in 2023, you recall saying to a member of the district attorney's office, I'm representing Kenneth Copeland as a witness only in the YSL trial.
I said that to you,
That
okay?
is your memory.
Yes.
Where was this? Is it on the phone?
Yes.
Okay. And what was it? Was it before or after Mr. Copeland resolved his criminal charges?
I guess before, because it was when we were talking about the bond issue.
And so what exactly did you say about your representation?
I said that I was representing him, and if you want to talk to him, talk to me.
And when you said you were representing him, isn't it true that you were talking about this criminal charge?
No, Miss Love, it's not true.
Did
And
you state that you were representing him beyond this criminal charge?
Had you finished your answer?
that's fine, yes.
Make sure he finishes his answer before you put the next one on the floor, okay?
Did you state that you were representing Kenneth Copeland in his capacity as a witness in the 22 SC 18357 case?
Yes.
Outside of the criminal charges?
Yes.
And did I hear you say that it was your testimony that you never once indicated that Kenneth Copeland had not paid you and you weren't even representing him in the criminal?
No.
So is it also your testimony that no one from the DA's office reached out to you to try and get you to go speak with Mr. Copeland
About what?
about his criminal charges?
Nobody tried to reach me to go talk to Mr. Copeland about his criminal charges.
Is that your testimony?
I don't know why that would be necessary.
That wasn't the question. Answer the question.
No, I don't recall anybody speaking to me about going to talk to Mr. Copeland about his criminal charges.
And so is it fair to say you also don't remember telling any member of the DA's office that you were on vacation and you were not able to deal with Mr. Copeland's criminal charge?
So I resolved Mr. Copeland's criminal charges. As far as I know, I resolved them to Mr. Copeland's satisfaction. And it may well be that at some point I was on vacation and not available to go speak to Mr. Copeland. I don't recall specific dates and times, but there is no issue with communication between myself and Mr. Copeland. Okay.
So as it relates to the question that I asked, do you recall there being a time when you conveyed to the district attorney's office that you were on vacation and could not go to talk with Mr. Copeland?
Ms. Love, if you have such a communication, then I'm sure it exists. The fact that I may have been on vacation a day or a week doesn't mean that I wasn't communicating with my client. Okay?
And if you would mind answering whether or not you recall it.
I don't recall.
All right, y'all, we've been at this for over an hour and it's really not particularly relevant anyway, so let's wrap things up.
Yes, Your Honor. When you spoke about Mr. Herzog and you said he was never involved in the case, do you know what it was that he was talking about?
He was calling me about Mr. Copeland testifying in the YSL trial.
And you spoke with him
Yes.
and he said that?
Yes.
And what did you tell him?
I told him that Mr. Copeland didn't want to testify.
Now, that was in March
That was in June of 2023.
And did Mr. Herzog ever say he was working on that trial?
That was my understanding of the purpose of his call to me.
Did he say he was working on it?
Yes.
You indicated, and Your Honor, I have about 5 more questions.
All right.
You indicated that upon questioning by Mr. Steele, that your concern regarding the district attorney's office communication with Mr. Copeland was Mr. Copeland's criminal exposure, and that the DA's office was seeking use immunity. And that you considered it ironic that a motion would be filed on June the 7th, considering there should have been, or wasn't, apparently there was no grant of immunity prior to that time. Do you recall saying?
I do.
You never once asked the district attorney's office what protections the immunity afforded to Mr. Copeland.
I'm familiar with what use immunity is, Ms. Love.
Do you recall telling Ms. Hilton in the presence of an investigator that you had never heard of OCGA 245507?
I believe that I did not know that that was the use immunity statute, but once I read the order and saw that it was the use immunity statute, I'm very familiar with use immunity. I've been doing this for 30 years.
And so you are aware then that there wasn't a need to seek use immunity, but that the motion was to compel Mr. Copeland to testify after the state had offered him immunity.
I feel that the motion and the order that was granted to Mr. Copeland did not protect him very much at all.
And finally, in writing to the email that is labeled Defendant Williams Exhibit Number 5, you wrote, "My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client."
Yes.
So what specifically did you intend to, you didn't include in here anything particular that you were worried about with the immunity deal, but you were very specific about Mr. Copeland's potential danger from testifying. Is that wrong or right?
We all know that Mr. Copeland is in danger by virtue of his testifying here.
Now, are you asserting that he is in danger for any member of the state from testifying?
No.
And what specifically did you want, more specifically, in the, because you do understand it's not an immunity deal. We can't use anything he says in any way against him.
Yes.
So understanding that, and that the motion was simply to compel Mr. Copeland to testify, given that he had received that, what much more specific information did you want to see in the meeting?
I would have demanded that he be given immunity from all state level prosecutions as a result of any action he may have had involved with any other individual in this case. And I would have seen if we could have included the feds in that as well.
And did you not understand Mr. Copeland, or did you want more than what he was entitled? Did you not understand him to have been afforded immunity for anything he was asked about criminally, whether it was from the state or the defense?
All that protects him from is from you using his testimony against him.
So you did not understand that it actually protected us from using that testimony in any way to get information about him to prosecute him regarding those matters? You didn't understand
It protects him from his testimony at trial being used against him, Ms.
that?
Love.
And anything derived from that
And anything derived from that testimony.
I speak one at a time. Anything derived from that?
testimony. Are you aware of that?
Yes, ma'am.
So given that Mr. Copeland could not be prosecuted for anything he testified about criminally, and the state could not use his testimony to go seek additional information or reasons to prosecute him, what is it that you would have been seeking to get?
So we are getting dangerously close to privileged communications here. So, but I told you what I would have demanded. I would have demanded absolute immunity from any state level prosecution for any criminal action involved in this matter.
Even those that he didn't speak about at all in the state?
Yes.
And could you tell us just why it is that you would have felt that that was
I think that's,
something that should have been avoided?
I'm not going to get
even
into
if it
that.
did not?
I'm not going to get into that, Ms. Love. I'm not going to get into that.
Yeah, I think that's all that I have. Thank you.
All right, is there any further questioning? Okay, Mr. Melnick, this time you can actually go. Thank you for your time. All right. All right, let's move on to the next issue. All right, we're done with this, right? Everybody satisfied?
Judge, I'll just proffer on the record, without calling unless the court finds it necessary, that the lawyer who was.
Okay, in just a second. Yes, sir?
I do not accept any proffer by Ms. Love. I've told the court that before, but that remains.
All right,
I'm rejecting it. If she
No,
wants to
I'm not.
testify, then that's fine.
don't talk while somebody else is talking. Let him finish, let me rule, then you can go ahead. I will listen to what your proffer is, because it's really not for Mr. Steele to accept or not, it's for the court to accept or not. Go ahead.
That Mr. Gotti, who was earlier president of court, was on the call that I think Mr. Melnick referenced that he had regarding, he said he spoke to Mr. Gotti about Mr. Copeland and his representation of Mr. Copeland as a witness in this case. Mr. Gotti would testify that Mr. Melnick specifically and explicitly said that he didn't want to have anything to do with his YSL case, that he was not representing him in his capacity as a witness in this case, and that when he was done with the criminal charges, that was it. I believe that he made some reference to used car salesman or something like that. I don't remember exactly, but if necessary, I will bring Mr. Gotti back at some point to testify.
All right, well, if I am presented with a motion that makes that testimony relevant, then we'll hear from him at that time. My point in all of this was just so that Mr. Melnick could feel like he'd cleared his name. All right. Okay, so anybody need a restroom break before we move to our next topic? All right, let's take 12 minutes and be back at 10:30.
And Your Honor, there's the omitted parts of the transcript. I just want to let you know before we move on to something else.
Omitted parts of the transcript. Yeah, that's what the next topic's going to be. Yes.
What's up, all?
Ms. Love.
So that went on way longer than I thought the judge was going to allow. But she cut it off, after quite a while. It was kind of weird because he only talked for a few minutes on his proffer, and then she moved right into the what is this about the ex parte that was supposedly off the record? I mean, I think she was just humoring them, basically, the judge. Like she said, she just wanted to give Melnick like a chance to clear his name. I was surprised she let that go on as long as it did, but whatever. But I am interested to see this next chapter because she seemed pretty skeptical of Steele's claim that there was some kind of off the record discussion in this ex parte. But that's the big issue here. I mean, all this stuff about whether Melnick was colluding with the attorneys or not, it's basically just to make Melnick like feel better about his professional reputation. I mean, they're trying to slam Love in it, but there's no real consequence. I mean, the judge is going to rule on the mistrial motion. That's what's going on here. I mean, she's going to issue a ruling on the mistrial motion that includes an analysis of the ex parte. And she has said that she doesn't really think this testimony, like whether he was actually colluding or not, isn't particularly relevant to the fact that in the end, prosecutors were concerned that they were, and that's why they called the ex parte. But I was surprised she let that go on for so long. But the next chapter is going to be really interesting because she did seem kind of dismissive this morning of Brian Steele's claim that there was some kind of off the record discussion in that ex parte about Donovan Thomas. She said she wanted Brian Steele to basically proffer like why he thinks that, or she said, kind of dismissively, or maybe we'll just move on. And what happened was that's when they brought Melnick back in to ask him all these questions about his representation and just kind of reiterating the proffer that he had. It was, I thought it was weird that Love went in on him like that. I didn't see any kind of benefit to her at all to do that. She just kind of let it go on for so long, but she's, the next chapter, again, I think is going to be really interesting because that's way more important to the case overall than this colluding allegation. Like if there was an off the record discussion about Donovan Thomas and it's not in the transcript and nobody has told the defense about that, that's a huge deal. I mean, that's actually the kind of evidence issue that could lead to some kind of mistrial, some kind of like actual prejudicial issue that ends the case. So I'm a little surprised that there isn't more focus on that, but that's what's going to happen when it comes back. But the judge seems really skeptical that that's true. So it'll be interesting to see what Brian Steele does to support that, because I mean, Melnick can't testify about that because he wasn't, I mean, even if he was, it's attorney-client privilege between him and Woody, but he wasn't at that meeting. It was Kayla Bumpus who was at the June 10th ex parte, but still she would have the same attorney-client privilege obligations to Woody. So I'm really interested to see this next chapter. Like, again, I was surprised that testimony went on as long as it did, because as the judges said, she doesn't find it particularly relevant to her analysis of the ex parte. So I thought Love should have kind of taken the tip on that and not gone in as much as she did on the questioning. But, she seemed to not be able to help herself. So, again, I'm really looking forward to this next chapter, because this next chapter, if it's true that they had some kind of that Woody discussed Donovan Thomas's murder on the record, or like in an open meeting with prosecutors, and the court reporter did not take it down and it hasn't been released, that's a really big deal. Like, that's the kind of thing that's actually going to tank this case. So, I don't know. We'll see. Somebody says, how can they prove that conversation if it wasn't in the transcript? Well, and it's a question of, so what is Steele's good faith belief for believing that? And it'll be interesting to see if the judge wants him to say more about where he got that from. I mean, I think she did. I'm just not sure how much she's going to press him on it, but we're going to find out here in a few minutes. I'm going over to the federal courthouse, not for like 2 hours. It's so early here in Los Angeles. It's not even 7:30 yet in Los Angeles, but there's a sentencing at 10 a.m. for a guy who shot two Jewish guys who were leaving religious services, and he's going to get like 40 years in prison. It's a hate crime case at LA federal court, but that's at 10 a.m. I was going to go over to the sentencing. I'm assuming they're probably going to be on lunch then, but they're going to be back here soon. And so testimony is supposed to resume on Wednesday. I mean, assuming she hasn't called a mistrial, which the only way she's going to do that right now is if something does turn out to be true about this secret meeting or this off the record discussion that Brian Steele is saying he heard happened. They need to get some kind of all the rumors about I don't know. I mean, I'm not sure. I do think that there's been a lot of like unprofessional discussions on YouTube, and just the presence of some attorneys on there is just I don't know. I mean, I don't know. I'm not sure. I mean, the rumor about who told who what, they're just that, rumors. And right now it does seem like there's some real unprofessionalism and in some of this, but I'm just going to kind of stay out of that and let the judge handle that. So we'll see. 6 minutes. We'll see how on time she is. I think she'll be pretty on time. I'm working on getting some clips up. I'm going to post something on TikTok here. So yeah, Rochelle, you get me, don't you? But yeah, I mean, it's just like let's not talk shit. It's just focus on the case and the judge. But yeah, but I mean, it's a rumor. I mean, yeah, it's definitely a rumor, guys. Nothing's been proven one way or the other. And frankly, I mean, who cares? I mean, the only one who was really interested in that was Judge Glanville. I mean, and he's not on the case anymore. So it's all just kind of extraneous, I think. But again, the who actually, was there actually an off the record discussion like Steele claims? That's a really big deal. That's why I'm surprised that there was so much focus on this collusion thing, because that's not going to get them anywhere. But if there is some truth to, there was a off the record discussion that wasn't included in that transcript, that's a really big deal. So hopefully they have some kind of way of fleshing that out. But anyway, we'll see how much more we've got here. Love really went into Melnick. I've got it recording on another phone, so I'm gonna upload here. But yeah, I'm trying to find a good clip of Love to post on TikTok. Her kind of tearing into Melnick. He got a little short with her here and there. But, let's see.
Because I had specific conversations with Don Geary about this case and about Mr. Geary's desire to use Mr. Copeland as a witness.
Somebody said, was Glanville playing chess to get off this case? You think when you read how clear Georgia case law is on judges aren't supposed to defend themselves, and then you look at what he did defending himself, it does seem like he was almost just begging to be kicked off the case. But remember, the recusal motions against him didn't even mention him defending himself. Like, that was just a reason that Judge Krause came up with herself. So my guess is the Fulton County Superior Court judges have been totally embarrassed at how mismanaged the trial is, because the inherent problem with the case is just that it's so big. But then also Judge Glanville was a terrible manager of the case. He would just let them go on forever, all these breaks. He couldn't manage it at all. So if anything, I think that's why he was recused. Krause was like, let's end this right now. Yeah, I mean, he was a horrible judge, and you would see his bad decisions on both sides. Like, if you actually go back to especially Friday when they were going over Woody's statements that they want to have, that prosecutors want used or don't use, and defense is objecting, it did not go well for the defense. I mean, if you listen to this discussion, and especially like Max Shard's objections to this stuff being, irrelevant character evidence, I mean, the judge was just shooting them down left and right. And she's much more efficient than Glanville. So she was going through faster. So I don't have an exact comparison chart about what she allowed in versus what Glanville allowed in, but she was allowing more stuff in. Like, Glanville was having the prosecutors take that out, take this out. I mean, he was way more receptive to the defense stuff on that. So this judge right here is already letting in more of Woody's statements. So the whole idea that they have a judge who's frankly smarter about the law and more focused on the evidence and is going to mainstream things more, I'm not sure who that actually benefits. It's like, does that benefit the defense or does that benefit the prosecution? Weinstein was saying, what Doug Weinstein told me, he thinks it benefits everyone to have the trial be more efficient. And I do think, just in terms of, your day-to-day existence. It's got to be better to have a judge who's a little bit more predictable. But when it comes to the law, like I said, go back and watch Friday when she was going through Woody's discussions. It didn't go well for the defense. She was not as open to their just, especially the video about the game. Shannon Stillwell and Quindarius Zachary threatening the game, that video where they're talking back and forth. We saw a lot of that under Glanville, and Glanville was really skeptical of it. He was saying he didn't see a nexus between that and the charged crime, and prosecutors were like, this refutes what they say about, how they're not a gang. Here they are saying, we'll go after the game if Thug wants to. And Glanville was really like, I don't know about that. I mean, I can't remember if he actually made a decision one way or the other. He's always just like would leave it open-ended and say, we can see when the time comes. But he was saying he didn't see a nexus between that. And then she's just like, yeah, I'm allowing it. Or, she's kind of did not have the long analysis that Glanville had and came to the conclusion that it's coming in, and kind of had some smart ass remark to the defense attorneys about how, maybe you could find some law to cite about why it's inadmissible. I mean, if you just listen to that conversation, it didn't go very well for the defense, and she's allowing in more than Glanville was allowing in. But she's also made some decisions in their favor, and she's taking more of a harsh tone with the prosecutors on things. So, and given her ability to kind of grasp the evidence better, if there is an evidence issue that develops, because right now, I mean, I saw somebody on Twitter say that, this case is like the Baldwin case on steroids. It's like, but right now there is not really any evidence issue for them to grasp onto and say that they need a mistrial over. I mean, they're really focused on the ex parte and, the coercion that they say occurred between the judge and Woody, but the judge is dealing with that right now. And the way she's analyzed it so far, it doesn't seem like she's going to lean towards a mistrial. But if there is some kind of evidence issue that develops, she's going to be much better equipped to deal with that than them, or than Glanville was, excuse me. But let me see, I got to get the stream set up on another computer here. But that's the next chapter here that's coming, is she wants Steele to talk more about his claim that he heard there's an off-the-record discussion about Donovan Thomas that didn't get included in the June 10th transcript. Because that's a really serious allegation. I mean, if that's true, and it turns out it is she could just end the case today. But yeah, I mean, Tammy says there will not be a mistrial. And yeah, because unless he can find some proof or get some kind of, she's convinced that discussion did happen, he's not going to get anywhere with it. But she's definitely interested in it. Here we go. They're coming back. There we go. That should be it. What are we waiting on? We're waiting on court. They said 10:30. It's 10:32 by my watch. I'm sure they'll be back. They'll be back soon. It's so hard to say whether he's going to beat the case. Right now, if it went to the jury, I mean, yeah, I don't think especially the first-degree murder charges, like for Donovan Thomas's murder. I mean, how could the jury convict Deamonte, Kendrick, and Shannon Stillwell of first-degree murder just based on what they've heard so far? I don't think they've proven that at all. But remember, we're still pretty early in the case. That's crazy to say because we're so many months in. But there's a bunch of evidence left that they have not gone over. So, I mean, it's hard to say. And also, One thing, there's just so many people spouting off their opinion and saying that, oh, there's no blah, blah, blah. There's no, it's up to the jury. And we don't know. I mean, we don't really know all that much about the jury. And I'm not sure if the demographics of the jury are very conducive to an acquittal. But the little that I've heard about them, like Doug Weinstein said, they seem really receptive to Keith Adams' cross. Like they kind of perk up when Keith Adams gets up there for a cross. It's been forever since we saw anything like that. But later this week, we should get back to the testimony. But when you look through the indictment at everything that's coming, like all the evidence they have in the indictment that we have not heard of yet, it's like, okay, this looks bad. But given the way the case has gone so far and the stuff that's come in, the way it's come in so far, I'd be skeptical of reading the indictment and thinking that it's all going to come in, you know, in this incriminating fashion that they make out. But we've got a lot of the trial left, and I'm not sure. I mean, I always thought that in the end, as maddening as it was, Glanville's lackadaisical approach to the trial and his massive comfort breaks, you know, it takes 2 weeks to get through one witness. I mean, Tick was on the stand for like 7 days over 3 weeks. I have always thought that kind of actually benefited the defense to have the prosecutor's case just take forever to put on. It's all over the place. I mean, streamlining it and making it more efficient. I'm not sure if that benefits the defense, but I don't know. We'll find out. We haven't even really gotten into any evidence yet. So anyway, they should be back soon. They should be back like any minute right now, right? I'm trying to get some stuff, get some clips up for you guys. But I see some movement. There we go.
Okay. Mr. Steele, move into our next topic.
I think
Okay.
I do need to get.
Oh, I guess if Zoom's relevant, I better get on the Zoom also. So give me a second to do that also.
Zoom illiterate, so I'm going to need a little assistance.
How can anybody be Zoom illiterate in this day and age after all of our COVID era Zooming?
I know enough not to turn myself into a cat.
Okay, if you can let me in, then I guess. Are we going to be hearing from somebody over Zoom?
I just have a brief TikTok that I need to play.
Really?
It's very brief.
Okay.
Well, this is part of the proffer, so it's your choice. I can do it or I cannot do it.
I have
Your Honor.
no idea what it's going to be.
I can tell you what it will be.
Why don't you tell me first?
This will be a TikTok of Mr. Copeland speaking to Miss Bumpus, where
Okay.
Mr. Copeland acknowledges that what is in the transcript the transcript is not complete from the June the 10th meeting.
Did Mr. Copeland read the transcript?
I don't know what Mr. Copeland is or not.
So
If you don't want to hear it, then I can just do my proffer, Your Honor.
I mean, if that's what it says, it shows Ms. Bumpus talking to Mr. Copeland.
Believe it or not, yes, Your Honor.
Okay, and Mr. Copeland says, whatever. I mean, I don't care. Play it.
You can take it for what it's worth. Your
Yeah,
Honor.
I'll just.
Let me just, if I can begin with my proffer, then I can play this,
Okay.
Your Honor. Is my understanding, based on my conversations with Ms. Bumpus, that while the transcript let me be more specific. The transcript of the June the 10th, 2024 ex parte meeting. And I'm not going to list everybody that was in the meeting, but that transcript was complete in the sense that when Judge Glanville was in the room and the court reporter was in the room, I have no basis to believe that that transcript is incomplete for when Judge Glanville was in the room. But there was a portion of that morning, a significant portion of that morning, based on my understanding, where it was Ms. Hilton was in the room, Mr. Copeland was in the room, Ms. Bumpus was in the room.
And how is that your understanding? Because I don't see that from the transcript. And I know I actually said that at some point, but I went back and looked, and let me reference y'all to, let me find it. All right, so the beginning of the transcript, it is just if y'all look at page 3, President Chambers were Judge Glanville, ADA Love, Attorney Bumpus, Court Reporter Weaver, and investigators Long and Hamilton. And then they have a conversation that goes through page 22. On page 23, the proceedings stood in recess from 9:34 to 10:03 because just before then, they had decided to get Mr. Copeland in and Ms. Hilton in. So when they go back on the record at 10:03, this is reflected on page 23, it's Judge Glanville, ADA Hilton, Attorney Bumpus, Court Reporter Weaver, investigators Long, Hamilton, some deputies, and then at some point, Mr. Copeland expresses that he might want to call his sister, and on page 36, Mr. Copeland says, this is not the sister, can I speak with her for a second, meaning Ms. Bumpus? And it shows that Judge Glanville, ADA Hilton, Court Reporter Weaver, and the 2 DA's office investigators leave chambers at 10:17, return at 10:33. Then Mr. Copeland has a question for the court. And then on page 46, a sheriff's office person comes in and tells Judge Glanville, we have a security issue, we need to stop for a minute. And it reflects that Judge Glanville and that officer, Lieutenant Dean, exit chambers at 10:45. Judge Glanville returned to chambers at 10:47. Okay, and then there's something about he might want to talk to his sister, and on page 52, they appear to maybe call his sister, and Ms. Hilton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. And the court says, hold on. And Judge Glanville exits chambers along with Ms. Hilton, Investigator Long, Investigator Hamilton, and the court reporter. They all leave from 10:53 to 11:28. When they come back in, and this was where I got confused, the court says, okay, all right, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? And I hadn't looked up to see who left before, so I thought maybe just the judge had left, but it appears that they had all left. So, I mean, I assume he meant obviously we know Ms. Hilton and Mr. Copeland had been talking prior to this. So I guess that's what he meant. But anyway, that's where I had gotten that. So where do you get your basis that they were in there at some point?
I get my information from Miss Bumpus. So
Okay.
perhaps, and I don't know specifically at what point. I don't know if Miss Hilton came back in the room prior to going back on the record. I don't know. But at some point, Miss Hilton, Mr. Copeland, and Miss Bumpus were in that room discussing things amongst themselves. And my understanding is that Copeland relayed information regarding the murder of Donovan Thomas and perhaps some other information that Miss Bumpus indicated would be Brady material. And so I just want to put that on the record that this happened.
Okay, so you can't put that on the record
Well,
that it happened. You can put it on the record that Ms. Bumpus told you it happened.
Well, Ms.
Is that
Bumpus-
what you're saying?
Yes, Your Honor.
All right, I'm here for something, if that's the case.
Okay. And then would you like to, are you interested in
If you
seeing this
want me
TikTok?
to, that's fine.
Okay.
No, I'm not interested in seeing it,
If-
but if you feel like it's relevant, I'll watch it.
Thank you.
May we approach briefly Mr. Kendrick?
Yes. We've got a resolution. That is that we're going to take 2 minutes or so. Mr. Weinstein is going to go refresh his recollection by watching the TikTok himself. And then he represents that there are really only about 10 seconds that are relevant. It is one question by Ms. Bumpus and one gesture and short answer by Mr. Copeland. He's going to make himself a written record of what that actually says, and he's going to proffer that. So we'll take a quick break and allow him to do that. Then he can come back and put a more detailed, specific proffer on the record, and we'll go from there. All right, so we're in recess again. Mr. Weinstein.
Thank you for giving me time to refresh my poor memory, Your Honor. So there is actually originally a YouTube video that I viewed on TikTok. And it's an interaction between Caleb Bumpus, Mr. Copeland's attorney,
Mhm.
and Mr. Copeland.
Okay.
And there's just is this feedback a problem? Okay.
Not right now, it's not.
Okay. So anyway, I viewed this interaction. I'll go ahead and proffer to the court the exchange that I witnessed. Ms. Bumpus says, Woody, is the transcript complete? Mr. Copeland then vigorously shakes his head back and forth, indicating no. Then Caleb Bumpus says, you say no? And then Woody responds with, you know that. So that's the interaction that takes place. Your Honor, as I think maybe you indicated, and certainly as the state indicated, perhaps the better source of this is Ms. Bumpus herself. She's here. I'd like to call her to the stand and we can hear her testimony about what took place on June the 10th, 2024, during the course of that ex parte that was not recorded in the transcript, not because of anything nefarious, but it would provide, I think, better insights into our position that there was Brady material June the 10th that was not captured in the transcript and not provided to us.
All right, let's hear it. Ms. Bumpus coming up, and Ms. Bumpus is basically, I think, been in court all morning. Is that right? Okay, coming up and take the stand.
Sure. Ms. Bumpus, would you please stand and raise your right hand? Do you swear the testimony that you're about to give today is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, please be seated. Would you please state your name for the record?
Kayla Bumpus.
And what is your relationship with respect to Mr. Copeland?
I previously represented him on criminal cases, but for purposes of this case, I was a stand-in attorney.
And what was your intent in representing Mr. Copeland?
To make sure that his rights were protected and to make sure that Jonathan Melnick was good to go.
All right, let's focus on the discrete issue that is before the court, okay?
Certainly. You were present in the June 10th, 2024 ex parte meeting, is that correct?
Yes,
Have you read the transcript to the ex parte meeting?
yes.
Um,
I'm not sure if that is already an exhibit in this case, Your Honor.
It is, it's a part of the record as a
Okay.
transcript.
Okay,
It's been filed
All right.
in Odyssey into the case.
Okay.
So I don't think it needs to be an exhibit unless you want to make it exhibit for the purposes of this hearing, but it's in the record.
okay. I'll just be referring to that transcript. So have you read the transcript from the June 10th ex parte meeting?
Yes,
And does that reflect everything that occurred the morning of June the 10th during the course of your meeting? I believe that was in chambers. Is that correct? That was compound.
That
Was
was
that
a
meeting
compound
that was
question.
compound. Was
Let's
that meeting
read
in
it that way.
chambers? Where did that meeting take place?
in chambers.
In chambers. And was the ex parte transcript that you read a complete recording of absolutely everything that took place in chambers that morning?
No,
Could you please tell me generally, when was there a time during the course of that ex parte meeting when y'all went off of the transcript?
Clarify what you mean by that, when y'all went off.
Was
of-
there a break in the proceedings at some point on the morning of June the 10th?
multiple.
Multiple breaks.
Yes,
And during one of those breaks, did you have occasion to speak to Mr. Copeland with someone else, with someone from the states, the state present in the room?
yes,
And when you had that conversation, that was off the record. That was without the transcript being transcribed.
yes.
Let's clarify who is in the room at
Yes.
this point in time.
Okay. Who is in the room? And again, let me just make clear on this. I only want you to speak about conversations that you had with Mr. Copeland that are not privileged, where, for example, someone from the state was in the room. Do you understand?
For sure.
Okay. When there was a portion of that meeting that was not recorded on transcript, who was in the room?
Myself, Mr. Copeland, and Simone Hilton.
Who else, if
Um,
anyone?
I don't know all the deputies.
But were there deputies in the room as well?
Yes,
Do you remember how many?
4.
Okay. Anyone else other than the deputies and the 3 people you just named?
Investigator Hamilton and maybe another investigator from the state.
Okay. Approximately how long was that?
Hang on a second. Was the court reporter in the room?
I don't know. I don't recall. I can't remember.
And at what point during the meeting did this allegedly occur?
Towards the end,
If you had a copy of the transcript in front of you, could you show me where? Like, if
I
you,
could get close, Judge.
okay. Do you have a copy for her?
I don't have, does anyone have a copy? I do not have a copy
Mine just
printed out.
disappeared. I don't know where mine went.
Max, do you have one?
I mean, I don't mind passing up, but it does have notes.
Maybe not. Let's get a
Okay.
clean copy.
Okay.
What had just occurred and then what occurred following it? What had just occurred prior to,
What had just occurred was we had been meeting for a really long time and I needed to go to the bathroom because I was stressed out. And
okay,
when I went outside in the hallway, Simone was outside in the hallway. So I guess she didn't want to be in the room with Mr. Copeland while I stepped out. That's all I can think of. So she was outside. She met me in the hallway. And she said,
okay, hang on before you get into what anybody said. So y'all are in chambers, like paint the picture for me. You're in chambers and then, and what happens for you to then leave chambers to go to the restroom?
I needed a break.
Okay, and so you leave chambers
Yes.
and Miss Hilton leaves chambers.
I don't know when she left because when I left, she was still in there. But when I came from the bathroom, she was in the hallway.
Okay, when you left chambers to go to the restroom, who was in chambers at the time that you left?
Mr. Copeland, the deputies that were with him, about 4, Miss Hilton, the investigators from the DA's office, the judge, and the court reporter.
Okay, so you took a bathroom break.
Yes.
And as far as you know, you left and then you have no idea when or if anybody else left. But when you came back, Ms. Hilton was in the hallway.
Yes.
All right, well then that's not the part we're talking about.
No. Well, I think it leads up to the part we're talking about, and that interaction with Ms. Hilton may
Okay.
be relevant to where we're about to go.
All right.
Could you please describe the exchange you had with Ms. Hilton in the hallway?
So she asked me, I think I get what you're saying. I think I get what you guys are trying to say. And if he's trying to do what I think he's trying to do, then that's not going to work. And I said, well, I don't know what you're referring to, but I guess we can come back in and you could talk to him about it.
Okay, and so when you said you can come back in the room and talk with him about it, was there any further exchange in the hallway?
No,
What happened after that?
we go back in the chambers,
Excuse me, we being you and Ms. Hilton.
me and Miss Hilton.
You go back into the chambers, and then would you say again who was in the chambers when you went back in?
Well, Mr. Copeland had then went to the restroom, so it was just me and Miss Hilton in chambers, and then they bring him back in. And
Did
then-
you and excuse me, I don't mean to cut you off if you hadn't finished.
No, then the same other people.
Okay, when you and Ms. Hilton were in the chambers prior to Mr. Copeland returning, did you and Ms. Hilton have any further conversation in the chambers?
No,
Okay, when Mr. Copeland.
Hang on. So you and Ms. Hilton go back into chambers. Do you go back? I mean, chambers there's an anteroom where the judicial assistant sits. There's a staff attorney's office. There's the judge's office. Where are y'all? The judge's office?
Yes.
Okay, and when you and Ms. Hilton go back to the judge's office, there's nobody else there but the two of you?
And probably the investigators from the state.
You don't remember?
Well, the deputies had to take Mr. Copeland.
Okay,
Yeah.
so Mr. Copeland was gone.
Yeah, he was in.
Was the court reporter there?
Yeah, she was there.
Was the judge there? If you remember.
I don't remember if he was in there.
Okay, so you and Ms. Hilton have a private conversation in chambers?
No, we don't talk.
Okay, y'all just walk back in and then what happens?
And then everybody comes back in.
Okay, who is everybody?
The judge, Mr. Copeland, the 4 deputies, the 2 investigators from the state.
Okay, we're just going to take it slowly, step by step, okay?
Okay.
All right. So those individuals return. Does Judge Glanville return to the chambers?
Yes,
Is the court reporter in the chambers?
yes.
Okay. When all of these people are in the chambers, what happens next? A step at a time.
Simone starts talking to Mr. Copeland about what we talked about in the hallway.
What specifically did Ms. Hilton tell Mr. Copeland about what happened in the hallway?
I don't remember what she said at the beginning, because then she says, wait, Judge, can you step out?
Who is the she that says, wait, Judge, can you step out?
Simone Hilton.
Okay, ask the judge to step out. At that point, does the judge step out?
Yes.
Does anyone else step out?
I don't remember if the court reporter stepped out, but I know she stopped taking down what we were talking about.
Okay, and she may or may not have remained in the chambers.
Correct.
Okay,
And so at this point, you're saying that the judge is out, you, Ms. Hilton, Mr. Copeland, 4 sheriff's deputies and 2 DA investigators are in chambers.
Yes, Judge.
Okay.
okay. Next step. What happens next?
Simone starts to talk to Mr. Copeland about, I guess this is the part about purging yourself and perjury and impeachment.
Okay, what specifically did Ms. Hilton say about purging himself?
About purging himself once he began to testify that he would purge himself of him being arrested.
Okay, what about perjury did she tell to him? Did Ms. Hilton say to Mr. Copeland?
I think some of this is on the transcript, but she reiterated the fact that pretty much she wanted him to testify. She didn't know what he was going to say, but there was one thing that they know that he didn't do that she would not allow him to testify to.
Okay. What did Ms. Hilton tell Mr. Copeland was the one thing he knew, she
All
knew?
right, let's not assume any of this because this is your witness, so don't lead her, okay?
Okay. So when you say that, what did Ms. Hilton specifically say regarding that?
Well, first, Mr. Copeland said, I can claim all of this. I can claim all of this. I might as well just say I did all of this. And she said, but we know you didn't do all of this. And specifically, we know you did not kill Donovan Thomas. And I will not allow you to get on the stand and say that you killed Donovan Thomas.
And when Ms. Hilton said, I will not allow you to get on the stand and say you killed Donovan Thomas, did she say anything else with respect to that?
Pretty much, I was explaining to Mr. Copeland about independent evidence because she said if she had any independent evidence to prove that he was lying about anything, she would just use his statement to impeach him. But she would not necessarily press charges against him for perjury. But she said that if he said this thing, this one particular thing, which was the unaliving of Donovan Thomas, that she may move forward with perjury. And Mr. Copeland says, well, it's not just about me knowing who killed him, but it's about, I know more about that infinity, and I know something about somebody who's not even on trial.
Okay, I'm going to stop you there a second because there's a lot to unpack, okay? So do I understand your testimony to be that Miss Hilton said that she would prosecute him if he lied about the killing of Donovan Thomas, but she would not prosecute him if he lied about other things?
Yes.
Let's go back to the infinity, because I didn't catch all of that. What did Mr. Copeland say about the infinity?
You just say, I know something about the infinity that y'all don't know.
And how did Miss Hilton respond to that?
No, I don't remember, but basically she just like, okay.
Okay. What happened next in that meeting? Oh, can I stop you a second? Had Judge Glanville re-entered the chambers where you were at this point?
No.
Okay. Please continue. What happened after the comment from Mr. Copeland about the infinity?
I think that, I mean, she really didn't say anything about it. She just kept moving forward with explaining to him about she wasn't going to go for that lie about the unaliving of Donovan Thomas, but whatever else you lie about, I'll just use it as impeachment. And that conversation went on for about 5 minutes or so, maybe a little bit more. I don't know. At this point, we've been in there for 2 hours. And they gave me a second to talk to Mr. Copeland, and then that was the end.
Okay. Who gave you a second to talk to Mr. Copeland?
I guess Simone.
Did Simone Hilton remain in the room while you spoke to Mr. Copeland?
Yes, but she couldn't hear what we were saying.
And why do you believe she couldn't hear what you were saying?
She couldn't, I know, because we were whispering in we scooted away from her and we just kind of whispered in each other's ear.
Okay. Is there anything else that happened during the course of this meeting where Judge Glanville was not in the room that you haven't told us this morning?
I'm not 100% sure, but I know there's one time where Adrian says something about Judge Closure.
Where, I'm sorry, who?
Adrian Love.
Okay, let's stop just a second, okay? Because I want to make sure we clarify this. I believe your testimony earlier was that Ms. Love was not in the room, at least during this portion of that meeting. Is that correct?
That's correct.
Are you referring to another portion of the meeting that happened that morning?
I don't remember if he stepped out or not. I just remember at one point she said, Judge, close your ears.
I don't remember if who said,
Okay, let's go back.
yeah, that's
Okay,
very
here,
unclear.
we're going to go back and try to clarify.
Let me.
Yeah.
All right. So at the beginning of the meeting, it is Judge Glanville, Miss Love, and you,
Yes, Judge.
the court reporter, and then whomever the deputies are. Mr. Copeland is not there. Miss Hilton is not there. Is that correct?
No deputies.
Okay.
They don't come until Mr. Copeland comes.
Okay. So then it is just the judge, Miss Hilton, and you, and the court reporter, correct?
And the investigators.
The DA investigators.
Yes,
Okay. And so is it that portion of the transcript that you're moving to now?
Yes.
Okay. All right.
And what did Ms. Love say?
I just remember her saying something about Judge, close your ears. And I can't remember if he steps out then for a second or not, but that would be the only other time I remember him stepping out.
What did Ms. Love say after Ms. Love said, Judge, close your ears?
I don't remember.
You don't remember? Okay. So we've discussed that one portion of the morning where the judge was not in the chambers. Was there another time that morning, other than that one time we've been discussing, was there another time that morning where the judge was not in the chambers, but there was a conversation among you, Mr. Copeland, and someone from the prosecutor's team?
No.
Okay, that's the only time.
Yes.
Okay, I don't have any further questions.
All right. Does any other defense attorney have questions for Ms. Bumpus? And we have a copy of the transcript now if anybody needs it. A clean copy. Yeah. It's sitting right up here.
Oh, I'm sorry. I didn't.
Go ahead, Mr. Steele.
Thank you, Your Honor. Good morning.
Good morning.
Counselor, was there a time in your presence that you heard someone give a direction for the sheriff deputies to shut off their body-worn cameras?
Absolutely.
Do you know who gave that direction?
Deputy Brown.
And do you know at what period of time or what point in time that occurred? Were you alone with your client? Was it throughout the whole time? Were you with Miss Hilton? What was going on when you heard that?
That was the first thing he said when the deputies brought Mr. Copeland in.
So as far as you know, I'm not saying the sheriff deputies followed that order, but they were ordered to turn off all body-worn cameras as far as you were concerned.
Yes.
And this conversation that you just relayed to us with Ms. Hilton, you and Mr. Copeland, your client, was that a calm conversation? Was it heated? How would you describe?
We had been in there for 2 hours. It was a high level of emotional tension, if that's a thing.
Okay, were people getting louder than we're speaking now?
Yes.
And who was that person or people?
Simone.
Okay. And when you were talking about Mr. Copeland not being permitted to take responsibility for the killing of Mr. Thomas, you know what I'm referring to?
Yes.
Did Mr. Copeland in any way take responsibility for that killing that day to Ms. Hilton?
Pretty much, he just said, you don't know what I did or didn't do.
Okay. And that was said to the prosecutor about the killing of Donovan Thomas?
Yes.
Do you know if you saw Ms. Hilton taking any notes or recording the meeting, or any of the people with her recording this meeting or taking notes?
I'm not aware.
It says, and the court just gave a transcript, I don't know where it is, but you can look at it. No one's trying to trick you. It says on page 40, towards the bottom, it's the Honorable
Yes.
Judge.
It's fine.
If you need to look at it, if you don't need to look at it, that's fine. Just let the record reflect. It should be on page 40. If you need it, it's June 10th. It should be 2024 ex parte conference that you were part of. And Judge Glanville says something to the effect, I'm not looking at, this is not a quote, but it appears to be to Mr. Copeland. Do you remember when Mr. Love told you that as long as you don't tell a bold-faced whopper, something like that? Do you see that?
Yes.
Can you just, so the court, unless the court has it in front of her, what line
I've got
that
it in
is?
front of me.
Do you know what line that is? Or it begins on?
12.
Okay.
Well, 9, but 12 specifically, which it's referencing to.
I couldn't hear the last part.
9 is when he starts talking, but 12 is when he gets into that part.
He being Judge Glanville.
Yes.
Okay. And what information do you have that Ms. Love spoke with Mr. Copeland about the bald face whopper?
What do you mean?
I'm sorry. Can you ask that again? Well,
Yeah.
apparently Ms. Bumpus didn't understand it any better than I did.
Yes. Do you have any information to educate us on when Ms. Love spoke with Mr. Copeland about you can't make a bald face, whatever it says, whopper?
Hang on just a second. Yes, Ms. Love.
My objection is that the question itself assumes a fact that has not been established.
Sustained.
Read what it says if you don't mind. Since it's
Tell me
in-
what page we're on again.
40.
Okay. Thank you.
The court, the state can still give you immunity. They can give immunity to whoever they want, okay? And they can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just the truth as you know it. And let her worry about, I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you in trouble is you not is you just invoking your First Amendment privilege because you've been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you lie, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
That part you said about, you remember earlier this morning, Ms. Love telling you about the bold-faced whopper. That's what I'm focused on. Can you tell us, were you present when Ms. Love spoke with Mr.
Objection,
Copeland that
Your Honor.
morning?
What's your basis?
Again, assuming facts that have not been established, the question I believe was, were you present when Ms. Love spoke with Mr. Copeland?
Okay, so I think that's based on the fact that what was just read out was read out. So I don't know that Judge Glanville's statement establishes that, but that's why he's asking it. So I'm going to permit him to ask that, and she can, keeping in mind that that doesn't establish that it occurred. Ask it as a more conditional question, I guess.
Do you have any information how that came about, if it occurred at all?
So the meeting was really long and a lot happened. I can't remember if Ms. Love was ever in the room at the same time as Mr. Copeland. So I don't remember them being in the room together. And if they were, they did not have any communication.
Okay. All right. Do you remember in that transcript, I have to get you the page if you don't remember, Judge Glanville handing something to you for Mr. Copeland?
Absolutely.
Can you tell this court what that was?
Which time?
Every time. So go one at a time.
So the first time, I believe he handed me a copy of the immunity order.
Okay.
And the second time, he handed me 2 statutes, one on perjury, and I think the other either on impeachment or, yeah, I think that's what it was.
Okay. Any questions, written out questions you remember being handed to you or Mr. Copeland? District Attorney's questions, was that given to Mr. Copeland?
No,
Okay, you remember that discussion?
no.
All right. I don't have any other questions. Thank you. Thank you,
All
Your
right.
Honor.
Any other defense attorney have questions for Ms. Bumpus? Okay.
Good morning, Ms. Bumpus.
Good morning.
Counselor, I wanted to take you back to that Monday, June 10th, 2024. When you arrived for court that day, you were arriving to represent Mr. Copeland, correct?
Yes.
As a witness.
Yes.
Okay. And where did you go when you entered the courthouse?
I came right here.
To this courtroom 1C?
Yes.
Okay. Did you ever request an ex parte meeting with the judge?
No.
To your knowledge, did Mr. Copeland ever request an ex parte meeting with the judge?
No.
Okay. How did this meeting come about?
I was down here and when I got here, the courtroom was closed. There was no one here. And so I contacted Mr. Chamberlain and he came down. He told me to call him when I got in the courthouse. So I called him when I got in the courthouse and I was right here. And he came down and got me, took me upstairs.
Okay. Were you ever told why you were going upstairs?
I was never told why I was going upstairs, but once I got upstairs, I thought I was upstairs because that was the only place I could talk to Mr. Copeland.
Okay. At what point did you realize that you were being made part of an ex parte meeting?
When Brian got up there and said it.
When what? I'm sorry,
Brian.
Who's Brian?
Attorney Steele.
Okay.
And that was the first time I really realized anything had happened because I had been sitting there and I did not realize what was happening.
Where are you? I thought you had just been brought upstairs to Judge Glanville's chambers.
But it was never a time where they said, oh, we're about to meet. They literally just start talking. So
Mr. Steele's there?
No, the first time I realized what had happened was when Mr. Steele made his motion in court.
Okay, so you were in chambers with Judge Glanville and Miss Hilton, and Miss Love, correct?
What I'm saying is,
You answer the question that I am asking you. You were in chambers with Miss Hilton and the judge. I'm sorry. There are two different parts to this ex parte. You were in chambers with Miss Love and the judge and a court reporter, and y'all had conversations, correct?
yes,
Okay. And you were aware prior to that morning that this case was being tried, correct?
yes,
Okay. And you were aware that Miss Love was a member of the prosecution team, right?
yes,
And that Judge Glanville was the presiding judge at the time.
yes,
And that there were defense attorneys on the other side of the case, right?
yes.
Okay. And so when you went into the meeting, you could see that there were no defense attorneys present, right?
No, but what I'm saying is, I didn't know I was going into a meeting.
Ma'am, I understand. Answer the question I asked you. You could see at that point in time that there were no defense attorneys present in the chambers, correct?
Yes,
Okay. So at that point in time, you knew this is a meeting with the prosecution and the judge and no defense attorneys, right?
what I'm saying is,
Ma'am, answer the question I am asking you.
I didn't realize it was a meeting.
Okay, so at the point when people started talking, let's call it a meeting at that point in time. Okay.
Okay.
And so you knew that the defense attorneys weren't there then, right?
Yes.
Okay. And so you knew it was an ex parte. If you knew the term ex parte.
Yes. I
Okay,
know.
go ahead.
And in the meeting, who initiated the conversation about the purpose of the meeting? Was it you?
No.
Okay, who was it?
All right, let me ask y'all a question. I can read what's in the transcript. So unless there's, something that we're saying occurred before, the court reporter said, okay, I'm ready whenever y'all are. I don't need an exposition of who said what. I can see it, okay?
Okay. I have no further questions.
All right. Ms. Matthews.
Ms. Bombas, good morning.
Good morning.
Just a few questions for you. At any time during the meeting that took place between the court, the prosecutor, yourself, Mr. Copeland, were you ever told by the court not to disclose any of the contents of the meeting?
All right, we are not going to replow the issue of Mr. Steele and held in contempt. That is moot. So to the extent that this is going to that, move on.
Okay, that's where I was going.
All right.
Thank you. No question.
Anybody else? From the defense team side. Okay. Ms. Love, do you have questions for Ms. Bumpus?
A few, Judge, just a few. Thank you. Ms. Bumpus, you were asked by, I believe, Mr. Steele, whether Judge Glanville ever handed Mr. Copeland anything. Do you remember being asked that question?
No.
Do you recall telling Mr. Steele or Mr. Shard or either member of the defense team this morning that in the June 10th hearing, Judge Glanville handed you a statute on perjury?
Can you say that again?
Do you recall testifying earlier that during the June 10th hearing, Judge Glanville handed you a copy of the perjury statute?
You can correct me if I'm wrong, but I thought the question was, did he hand it to me to give to Mr. Copeland?
Do you recall testifying that Judge Glanville handed you a copy of the perjury statute? Or better yet, let me do this. Did Judge Glanville give to you a copy of the perjury statute?
And said, hand this to Mr. Copeland? Yes.
Okay. And did Judge Glanville give to you a copy of the immunity statute?
And say, hand this to Mr. Copeland? Yes.
All right. And when you responded, let me back up. So do you not recall being asked in this courtroom today, did Judge Glanville ever give to Mr. Copeland anything?
I don't recall.
Do you recall what you were asked when Do you recall testifying that Judge Glanville gave you both a perjury statute copy of that and a copy of the immunity statute?
Yes.
Okay. Do you recall what question you were answering when you made those statements?
The question that I was answering was, did Judge Glanville give me something to hand me a statute or hand me anything in a meeting?
And you don't recall him asking whether Judge Glanville handed Mr. Copeland anything?
Objection, asked and answered.
Yes, thank you.
I mean, I'm not sure we've got a clear answer on it, but does it matter?
If she, there's a reason that I'm asking the
All
question.
right, well, go ahead. You can ask it again because I don't think anybody's clear on it yet.
Do you recall being asked today whether Judge Glanville ever handed Mr. Copeland anything?
I believe that I just stated that he handed me two things.
Ms. Bumpus, I don't think she's asking you about what happened. I think she's for some reason asking you about the question that was asked to you on direct.
Do you recall being asked if Judge Glanville gave Mr. Copeland anything?
I don't recall.
Okay. At the time that you were called to the meeting, you already knew that Mr. Copeland had been granted immunity, correct?
Incorrect.
Okay. At the time that you assumed representation of Mr. Copeland, you were aware that he had been arrested though, right? You knew that Mr. Copeland had been arrested?
No.
Okay. At the time that Mr. Melnick spoke with you about standing in his stead on that Monday morning, did you learn during that conversation with Mr. Melnick that Mr. Copeland had been arrested?
No.
At what point did you learn that Mr. Copeland had been arrested?
After he had been arrested.
Was that before or after the Monday morning meeting?
Objection, Your Honor. You asked us to just focus on the content of that meeting. You asked me to not get far from that, and we're far from that.
Your Honor? Yeah.
Yeah, what does this have to do with whether or not some off the record discussion that Ms. Hilton was privy to occurred?
Your Honor, the reason I was asking about the giving to Ms. Bumpus the statutes is that my understanding is that at the time that she was called to represent Mr. Copeland, she was not familiar with certain statutes.
Okay, well, maybe not, but that's not relevant to what we're trying to figure out here.
And so to the extent that she was asked by the defense whether Judge Glanville gave to Mr. Copeland anything, and she then responded, he gave it to me.
All right, I don't recall. I'm sorry, go ahead. Go ahead.
I was establishing the reason he would have given her that, and I was establishing further the extent of the questions that I had for her dealt with her understanding of her responsibilities. And then finally, I was going to ask her, she'd already testified to my memory that she doesn't recall this counselor ever being in the room with Mr. Copeland, and if there was no communication.
Okay.
So I was going to.
That part seems relevant. You can ask about that.
Miss Bumpus. Do you have any memory of Miss Hilton and me being in the room while you were in the room with Mr. Copeland?
I have some memory of all of us being in the room for a very brief moment of time.
When you say all of us, who is all of us?
You just asked me, do I have any memory of you, Ms. Hilton, and Mr. Copeland being in the room? I remember at one point you came back, but I can't remember exactly what happened while you were there.
Is it your recollection that I was there when Mr. Copeland first came into the room?
No.
And when you say you remember that I came back, where is it that you're remembering that I came back to?
Either, I don't remember. Maybe it's when Miss Hilton came back. But at one point, all three of us were in the room.
Who's all three of us
Me, Miss Hilton, and Miss Love
in chambers?
in chambers.
Was Mr. Copeland in the room?
I don't remember. I just said I don't remember.
Well, I mean, it's kind of important. We're relying on your memory for certain things. So
I said,
were there deputies in the room then?
what I'm saying is if Mr. Copeland was ever in the room with Adrian Love, then it wasn't a long, extended amount of time, and I don't think there was any communication. I remember that Simone left, and it was just me, Adrian Love, and the judge and the court reporter.
All right, so your recollection is that at the beginning of the meeting, before Mr. Copeland ever arrived for the first, when he ever arrived with the deputies, that there was a point in time when the judge, Miss Love, Miss Hilton, and you were in chambers?
There was a point in time where Miss Love and Miss Hilton were in chambers with me. I cannot affirmatively state whether Mr. Copeland was there or not, but there was at least 2 minutes of us all being there together.
Did y'all have any conversation at that time?
I can't recall because Miss Hilton was doing all of the talking. I honestly believe it was when Miss Hilton left at the beginning, when we first got in chambers, when we were in not the judge's office, but all of us were there.
Antechambers, like outside of
Yes.
chambers, but inside of the door.
Yes.
Who is all of us?
Simone Hilton, Adrian Love, me, Investigator Hamilton. Mr. Chamberlain was in and out. The judge was in and out talking to us, and that was it.
In and out talking to you about anything substantive?
No, Judge.
Okay. All right, so y'all are all out where the JA, the judicial assistant, sits.
Yes,
At
Judge.
first, okay, we'll call that the antechambers, ANTE chambers. So when is it that any of you go back into Judge Glanville's actual chambers, his office?
Adrian Love says, Judge, can we talk to you for a second in chambers?
Okay, and who goes then?
Just me, her, Adrian Love, and Judge Glanville and the court reporter.
Okay. Go ahead, Ms. Love, if you had anything else.
Thank you. Ms. Bumpus, there were investigators present or no? When you, me, judge, the court reporter first went back?
I can't remember.
Do you recall a comment from either the court reporter or the judge just joking about the fact that I'm not allowed to go anywhere without the investigator?
No.
And when you say that we went into the chambers, you, me, the court reporter, Judge Glanville, was Judge Glanville's deputy there?
Yes. I guess if he's a deputy, I don't know.
Which person was there? Judge Glanville, which sheriff's office personnel, do you remember?
No.
And where was that person situated when you, me, Judge Glanville, the court reporter went into the chambers?
I have no idea.
That person was in chambers with the 4 of us, 5 of us?
I don't remember. At some points, I don't remember about when he was walking in and out.
Okay. And by that, by he, you mean a sheriff's office personnel?
If he's a sheriff, I don't know what he is.
Do you remember, do you have any memory of the investigator, an investigator being present with me while I was in there?
I don't remember. I know there were investigators there. I don't remember if they came in chambers when you came in or after Ms. Hilton came in.
And seeing the transcript, does it do anything to refresh your memory about who all was there?
No.
Okay. And when you testified earlier that at some point after I left the first time, that Simone, me, and you ended up in a room together in chambers. Do you recall testifying that way to the court just earlier today?
Yes, at one point, me, you, and Simone were in chambers together. Like I said, it was a brief moment, and I don't remember you saying anything.
But that was, are you saying that now that was after I left the first
I really don't remember.
time? Okay. So your memory, you know that at some point you, me, and Simone are in chambers together. You cannot recall whether after I left the first time I ever came back.
I cannot recall.
Okay. And when you said, let me ask you just this pointed question. Did Kenneth Copeland ever say, I killed Nut while Simone Hilton, to Simone Hilton while you were there?
Can you ask the question again?
Did Kenneth Copeland ever say to Simone Hilton, I killed Nut?
No.
Did Kenneth Copeland ever say to Simone Hilton, I killed Donovan Thomas?
No.
Did Kenneth Copeland ever say that he killed anybody to Simone Hilton?
No.
Did he say any of those three things in Simone Hilton's presence and hearing, to your knowledge?
Can I answer that with a non-yes or no question, Judge?
With a what?
With an explanation, because he didn't say yes, or he did not say I killed, but he said, you cannot tell me what I did or did not do.
Okay. That's the extent that he said.
Yes.
Okay.
When you spoke about someone asking the sheriff to turn off their body cameras, was that Miss Hilton? Did you say Miss Hilton told the sheriffs to turn off their body cameras? Did I hear that wrong?
You heard that absolutely wrong.
Please tell me who it was.
I clearly said Deputy Brown.
Thank you.
Mhm.
Thank you for clearing that.
You're welcome.
Do you recall what was being talked about when Deputy Brown told the sheriff's deputies to turn off their body cameras?
Nothing. That was the first thing that he said when he walked in the room.
And at that point was Miss Hilton, you, Mr. Copeland, judge, court reporter, and DA's office investigators all present in the room?
I don't remember who was in the room. It may have just been me.
So it may have just been you when Deputy Brown said to the sheriff's deputies, turn off your cameras?
I don't remember exactly who was sitting in the courtroom.
But that's
I mean, in the
chambers, but that's possible?
It is possible.
It's possible it might have been when you and Mr. Copeland were just in there together?
It wasn't.
Well, Mr. Copeland had to have been in there, right? Because you said the deputies didn't show up until Mr. Copeland arrived.
No, what I'm saying, Judge, is that was the order as he walked in.
Right, but what did you say might have just happened when it was just you?
Nothing. I was saying I may have been the only one sitting there. I can't remember, but there wasn't like, oh, step out. It's as soon as they walked in, this is what was said as Mr. Copeland was walking in.
And was there any, did you request at that point that they brought him in to have a private meeting with your client at the time?
At that moment, I hadn't requested anything.
To say you don't know why they were told to turn off the body on him?
That is correct.
Okay. Did you ever hear anyone from the state ask the deputies to have those body-worn cameras turned off?
No.
You testified earlier that Mr. Copeland said something akin to, I can claim all of this. Did I hear you right?
Yes.
Okay. And who was he talking to? And
Simone.
okay. And did you know, or did he ever make clear what all of this was that he was talking about?
I believe he was referring to everything that,
Wait, that's not the question. It wasn't what do you think he meant? It was, did he ever make clear?
he said everything in this case.
He said the words, everything in this case?
I don't know if those were his words verbatim, but that's what he said.
Was the court reporter there when that happened?
I don't know. This was an off the record conversation.
Okay, so it was off the, so when what about his words? What words did he say that makes you now say that's what he said if you don't remember exactly how he put it?
I said I don't remember his words verbatim,
Right.
but I was there and he said, I can claim all of this. I can take all of this. That's what we were talking about. We were talking about this case.
Okay. Is what you just testified to the extent of the words that Mr. Copeland spoke regarding claiming something?
Can you repeat the question?
Yes, ma'am. Is what you just testified about the extent of the words Mr. Copeland spoke about claiming something?
I don't want to say that is a complete lead to the extent because he said it over and over. He said it various ways. He changed the way he said it.
Do you recall what specifically was being discussed at each of the points that he said that? Specifically.
Overruled.
Specifically, not generally, not broadly, specifically what was being discussed at each of the points where he said, I can claim all of this.
The whole conversation was about Donovan Thomas's unaliving.
Are you familiar with any of the shootings that occurred after Donovan Thomas was killed?
No.
Okay. Are you aware or are you familiar with any allegations about any retaliatory events that occurred that the state considers a part of the Donovan Thomas shooting?
No.
At what point, what was being asked of Mr. Copeland when he made the statement that you testified, it's not just about me knowing that, it's about who was in the infinity? At what was being asked of him when he said something like that?
Nothing was being asked of him.
Okay. Did he just sort of blurt it out on his own?
Yes.
Okay.
And what he said was, I know something about that infinity that y'all don't know. And it got something to do with somebody who's not even on the case.
Okay. Did he ever make clear what it was that he knew? To Ms. Hilton in your presence?
He wasn't given the opportunity to.
But what do you mean?
She continued to talk about what she was talking about.
Okay. Did she ever tell him, don't talk to me about that?
No.
Did you ever hear him sort of interrupt her at any other time, at any time?
The whole conversation was them interrupting each other.
Okay. So did he ever interrupt her to give her more information or to tell her what it was about the infinity that he knew?
No.
Okay. When you said, Adrian said, Judge, close your ears. Did you mean to say Adrian said, Judge, close your ears?
You?
Yeah.
Yeah, you.
Okay. At what point are you alleging, are you saying, does your memory tell you that I told the judge to close his ears?
I don't really remember exactly what was saying. I don't know if it was you and Simone in there, but something about We were having a conversation. Me, you, and Ms. Hilton were having a conversation about, I don't remember what we were talking about. And you said it, and then you said, Judge, close your ears.
And what did I say after I said, Judge, close your ears?
I don't remember.
All right, so then it's now your recollection that there was a point in time when you, Miss Love, Miss Hilton, and the judge were in there and Miss Love was talking.
Judge, I've said that she never talked while Mr. Copeland was in the room.
Okay, and you don't even remember really whether she was in there or not when Mr. Copeland was in the room.
If she was,
She, Miss Love.
It was very brief, but no.
Okay, but you said before, I thought, that there was maybe a 2-minute time when you, Miss Hilton, and Miss Love were in a room together.
Yes, that's what I'm referring to.
Okay, so that was in front of also Judge Glanville? Because you just said it was, so I'm
Well,
trying to get clarity.
Here's the clarity. He wasn't at the table with us as normal. He was turned around on his computer, but still inside of his office.
Okay. So when did this occur during, so we have the beginning of the ex parte being Miss Love, all of y'all are standing outside in the ante room and Miss Love says, Judge, can we talk to you for a minute or something to that effect? And then who all gets up and goes into Judge Glanville's chambers?
Simone has left to go to something at that point. It was just me and Adrian Love.
Okay, and who else?
And the court reporter. And she says maybe her investigator. I can't remember.
Okay, and so the three of you talk for some amount of time,
Yes.
the three of you being Miss Bumpus, you, Miss Love, and Judge Glanville?
Yes.
All right, and then tell me when that changes and it becomes more or fewer of you in that room.
The first person to join us is Simone when she comes back from court.
Okay, and is that at the same time that essentially the same time that Mr. Copeland also joins you?
Maybe within a minute or so. They don't come in like at the 8.
Okay, so they come in essentially together. And where's Miss Love at that point?
She leaves when Miss Hilton comes, but she does stay for, like I said, there's a brief conversation with me, Miss Hilton, and the judge.
And the judge?
Well, in the judge's chambers. The judge is
Okay,
not.
with you, Miss Hilton, Miss Love, but it's not a part of the proceedings yet because the judge didn't even pay attention. He's over there working on his computer.
Yes.
What do y'all say at that point in time?
I don't remember what the conversation.
Anything of substance?
It was about maybe plea deals. I remember she said to me.
She who?
Adrian Love. I remember
Okay.
she says, which I can't forget this, is I don't know who's worse, you or Jacoby.
What?
That was the thing. That was the nature of the conversation.
I say that again.
She said, she tells me she doesn't know who's worse, me or Jacoby.
Me or Jacoby?
Yeah.
Jacoby Hudson?
Yes.
What does that have to do with anything?
I don't know.
It has nothing to do with this case.
No, that's what we're talking about. You asked me what we were talking about.
Okay, so something that had nothing to do with this case.
And then something comes up about, I don't know if it's plea deals. I don't know. It was something about this case where she says, Judge, close your ears.
Okay. So this is before y'all kind of gone back on the record. The judge isn't paying attention anyway. He's in the room, but he's over at his computer. Y'all are over at his conference table. Is that what your recollection is?
Yes.
Y'all are talking about entirely other things. And then
I wouldn't say entirely other things, but we're not talking about the Mr. Copeland.
Or the case. If you're talking about Jacoby Hudson, you're not talking about the
No,
case.
we're talking about the case. She's talking about, I guess she's talking about the reference to me hugging people. I don't know. But we were talking about the case.
Okay, anyway. And then at some point, Miss Love, to your recollection, says, Judge, close your ears because she wants to talk to you about a plea deal.
I don't know exactly I don't remember exactly what she was talking about, but it was something pertaining to the case. And
Okay, but
She
you
doesn't want
don't,
to talk to me about a plea deal because I'm not a defense.
right, that
attorney.
wouldn't have made any sense.
But she was discussing something pertaining to the case, and she says, "Oops, judge, close your ears."
And how long does that conversation go on?
Like two or that's the 2 minutes I'm talking about.
Okay. And then what happens to Miss Love?
She leaves
She leaves. And then when do y'all go back on the record?
immediately.
Okay.
Well, no, I talked to Mr. Copeland for a second.
Okay. Privately or,
Privately.
okay. And then y'all go back on the record. And then does the record reflect everything the record reflects accurately? Other than whenever this conversation between you, Miss Hilton, and Mr. Copeland allegedly occurred?
Yes,
Okay. Do you have a copy of the transcript in front of you at this point?
yes, sure.
Can you kind of point out where this conversation allegedly occurs?
It's somewhere around page 40.
Okay.
Between 39 and 40.
Okay.
Your Honor, could I just get, if it's between 39 and 40, are there any specific lines?
Well, it was like off the record, so I wouldn't know exactly which line it starts back at.
Okay, but you had represented previously that Judge Glanville was not in the room at that point in time.
Yes, he was asked to leave.
Okay. So him being asked to leave isn't reflected. Is that right?
Let's see.
Okay. Do you remember who asked him to leave?
Miss Hilton.
Okay. And that's not on the record either?
No.
And you can't remember whether the court reporter stayed or left?
I can't remember whether she stayed or left, but she definitely stopped taking down.
Okay. All right. And when did you, sorry, Miss Love, go ahead. You know what? Go ahead. I'll save my questions.
Your Honor, I honestly defer to the court. Please continue. I have no.
All right. So after this conversation concludes, then what happens? And by this conversation, I mean the conversation you referenced that is not reflected in the record, but that takes place between you, Mr. Copeland, and Ms. Hilton. What happens after that? But if it's not in the record, it's not going to be in the record. So you just tell me from your recollection, what happens after that?
That's probably towards the last 5 minutes of this meeting.
Okay.
And so we go back on the record and
So the conversation finishes. How does everybody get back in the room? And how is it that y'all go back on the record? Give me the details of that.
she just, we just finished the off the record conversation and just Simone just says everybody can come back in. And then okay, wait, Judge, I'm sorry.
Mm-hmm.
It's actually,
Your Honor, does the court mind if I speak?
Go ahead.
I would say that the conversation actually happened around page 46, 45.
45, okay. And is that conversation in fact reflected on the record?
No, but I don't know how.
I mean, so how are you sorting out, oh, it's around 45 that it occurs?
Because I try to get the conversation on the record.
What did you say? To get the conversation or to try to get the conversation on the record?
I say,
I'd like to hear it from your recollection without reference to the transcript first, okay?
I'm trying to make sure. So I just.
So Ms. Hilton says, Judge, can you leave? And at that point, do you say anything? Like, no, Judge, stay, or anything like that?
No, she already told me in the hallway that she was going to ask the judge to leave and have a
Okay.
conversation with him.
Okay. So show me where in the transcript y'all come back from the restroom break.
Well, you want me to, you asked me to.
Now I do want you to look
Okay,
at the
okay.
transcript, yes.
Okay, I'm sorry. You asked when, okay, I think we came back.
No,
around-
Yeah, the restroom break, show me the restroom break.
See, that's not in here with me getting up. I don't know how to find that.
Okay, so the restroom break, y'all take, but it isn't reflected.
Yes.
Okay. Is the restroom break after Mr. Copeland's with y'all?
Yes.
Okay. All right. And it's immediately after this restroom break that you and Ms. Hilton and Mr. Copeland have the private conversation?
Yes, sure. And Judge, you asked me a question earlier that I didn't get to answer.
Okay, what's that?
You asked me, can I, without looking at the transcript, tell you how I tried to get it back on the record?
Yes. Can you give me a second before you answer? Because I'm looking for something in particular. All right, so y'all take a restroom break. You see Miss Hilton in the hall. Y'all walk back in. Mr. Copeland's gone because he's taking a restroom break at that point. The court reporter is there. Mr. Copeland comes back. The judge comes back. And that's when Miss Hilton says, oh, wait, Judge, go back out.
Yes.
Okay. All right, now what were you going to answer?
You asked me how did I get it back on the record?
Yeah.
So after the conversation, I say pretty much, I want to get what she just told him about what he cannot go to jail for.
Okay.
Because the whole point of the off the record conversation is he's trying to figure out, can he go to jail for lying?
Mm-hmm.
And so I'm trying to get back on the record that she says that she's not going to prosecute him for anything other than one thing.
Okay. Okay, and so y'all have had, the three of you have had this conversation. Judge is gone. You can't remember whether the court reporter's there or not, but then what happens?
That's what I'm saying. That's on
So
page.
then you say, I'd like to get this on the record, or,
No, we go back on the record.
okay, so how does that occur?
No, she just says, let's go back on the record. Simone.
So Ms. Hilton says, let's go back on the record.
Yes.
So you don't say, I want to get this on the record.
No, I just do my best to get it on the record when we go back on record. It's in the.
Oh, I see what you mean. You don't mean, I'm really trying to get this on record. You mean Miss Hilton says, all right, let's go back on the record. And then you try to like give a rendition of what occurred.
Yes.
Okay. And that is reflected where?
On page 48.
On page 48.
Well, between 47 and 48.
Okay. All right. And does page 47 and 48 reflect the off-the-record conversation that allegedly occurred between you, Miss Hilton, and Mr. Copeland?
There's a part where I say, so he can go to jail for anything but what? Okay. And okay, page 51 specifically, I'm asking, I tell him he has to make a decision. And I ask, so if he starts testifying today, is he going home today? And then I say, but if he says he don't recall to everything, he'll be okay.
Okay.
'Cause
So, at that point, between, you know, whatever you said, 47 and 51, y'all are back on the record, right?
yes, Judge.
Nobody's like declining to take down what you're saying.
No, Judge.
Okay. So anytime during that point in time, do you say, let the record reflect that Miss Hilton, Mr. Copeland, and I had an off the record conversation, and I'd like to put on the record what was said during that conversation?
No.
Okay.
And also on page 51, I say, I think, are you saying you want to get up there on the stand and say something?
Uh-huh.
And then it's no response, because he just looks at me.
Okay. All right. So does 47 through whenever that last page number was, does that accurately reflect whatever was said during the alleged off the record conversation?
It doesn't accurately reflect, but it does. I do try to mention what we talked about, but it doesn't accurately reflect everything that we discussed.
All right. So was there something else that you discussed that you should have said, oh, and by the way, this also happened that you didn't say?
I'm confused, Judge. What do you mean that who didn't say? That
You.
Simone didn't say?
No, anybody during the alleged off the record conversation, when you're making this record, after y'all go back on the record, you said it still wasn't accurate. And you also said you weren't stopped from saying anything during that part. So what is it that you should have said that you didn't say?
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay. All right. All right. So when is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date, but somewhere.
Sometime in late June?
Yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you are an attorney licensed and barred to practice in Georgia, right?
Yes.
Okay. And as such, you have a duty of candor to the court.
Yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all of that happened, it's been on recess for so long.
So you've been in court when we've been in session for the last week or two, right?
Yes.
Okay. So I was presiding at that point in time, right?
Yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney, I believe that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay. All right. So what is your answer then to my question?
Can you ask me again? I'm sorry.
Did you ever at any point in time bring to my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay. Why is that?
Well, because of what I kind of just said, I don't
Okay.
believe that it was incomplete per se.
Okay.
Minus the off the record conversation, but there are a lot of off the record conversations that are had that are not included in transcripts, and that's
True.
not unusual. to me.
Okay, all right. So you don't actually believe it's inaccurate then?
No, I just think it's missing the off the record conversation. I'm not
Okay.
missing. I just think that the defense did not have knowledge of the off the record conversation.
Okay.
Not that it's missing from the transcript per se.
Okay. Because it was officially off the record, is that what you mean?
Yes, Judge.
Okay. And did you ever, if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay, so at some point you brought it to the defense attorney's attention? Is that how you decided to deal with it?
I had a conversation with the defense attorney. I don't want to say I brought it to them, but we just had a conversation
Okay.
about what happened.
All right, Ms. Love, do you have other questions for Ms. Bumpus?
Ms. Bumpus, did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hilton on June 10th?
That I had with Ms. Hilton and Mr. Copeland? Yes.
When did you tell them?
The same day.
Did you tell them everything you remember about it?
I told them everything I remembered.
And do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour?
Was court in recess or was court in session when you told them?
Court was in recess.
Between the time that the conversation between you, Ms. Hilton, and Mr. Copeland ended, and the time that you told defense attorneys all of the details you could remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in session between the time that you finished your conversation with Ms. Hilton and Mr. Copeland
Mm-hmm.
and the time you told defense? What happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had the conversation with defense? Just in that moment, from chambers to conversation with defense,
Oh, no,
court had not resumed.
no.
And when you said earlier,
I mean, because remember, we came straight down here and sat down and immediately started, so I didn't speak to anyone.
and when you were speaking earlier about after Mr. Copeland came in, you said you weren't sure whether I was in the room.
Mhm.
Did the portion about judge close your ears occur before or after Mr. Copeland came into the room?
For sure before.
Okay. And at that point, was the court reporter taking down anything?
No,
And at that point, did the court give any indication, did the judge give any indication that he was paying attention to whatever it was?
I can't answer that.
Did he give any indication? Did you see any indication that he was paying attention?
I can't answer that.
Yeah, you can.
I don't know. I wasn't paying attention to him.
So no, as far as you know, he gave no indication. She's asking from your personal observation. Answer it as to that. That's what she's asking you.
I would have to say no, but I would also say I wasn't looking at him at all.
Do you remember Ms. Hilton at some point talking about the judge closing his ears at any time?
I don't remember.
And we're looking at the transcript at all refresh your memory,
I'm sure.
okay? Would you take a look on page 26, line 5 of the transcript? And since it's a part of the record, read from line 2 to the end of line. Let me just ask you this. Do you see where Ms. Hilton says, Judge, you might want to close your ears?
Yes.
Did you hear that phrase or something like that said more than once in that meeting?
Yeah, before Simone got there, I know exactly what I'm talking about. So are you in here at this point?
So my only question is, did you hear that phrase more than once in the meeting?
I can't remember if it's that exact phrase, but I heard you say something to that extent, and I heard her say that.
Okay. Were you the first person, to your knowledge, that brought to defense's attention that there was in fact a meeting in chambers?
No,
Who, do you have personal knowledge of who that person was?
no,
How then do you know that you were not the first person who brought that to their attention?
because they asked me about the meeting.
Did they give any commentary to you that led you to believe that they knew what was said in the meeting?
Yes.
What did they tell you?
Is it true that?
Sure.
Defense attorneys, they thought also an all-inclusive view.
Yes, sustain. Can you be
Yes.
specific?
Who specifically came up to you and asked you about the meeting in chambers?
There were multiple attorneys that specifically talked to me at one time.
Would you please apprise the court of the names of those multiple attorneys?
Excuse me, objection, Your Honor. We're still far afield again of the limited subject matter that you asked me to stick to.
Your Honor, as it pertains to Brady or whatever information, I think it's quite relevant. Who knew what and when, as it relates to what was said during the meeting?
Okay, well, I don't know if it's relevant who revealed it, who revealed that a meeting occurred. Ms. Bumpus has said that essentially, if I understand you correctly, that at some point during the day immediately following the meeting, the day of the meeting, you had a conversation with some defense attorney or defense attorneys, and we can sort out who, where you relayed to them everything you knew and everything you recalled about what went on in the meeting, including the off-the-record conversations, right?
Yes.
Okay. You can figure out who that is now.
Thank you. Who was it? Name the attorneys that you referred to just a moment ago.
Just a moment ago with the question she asked me, Judge Whitaker?
With the one I asked.
I mean, it's the same topic, right?
Okay, ask the question again.
Which attorneys by name first came up to you and asked you about the meeting?
See, Judge, that's two different questions.
Can answer the question Ms. Love asked you.
I don't recall, but I think Judge Glanville did judicial notice of me on camera. I don't recall.
No, my only question to you is who first came up to you and asked you about the meeting?
I don't recall everybody who was there.
Who do you recall?
I recall Attorney Steele and Attorney Adams. And I can't remember who was the other person.
Do you remember how many?
How many
Lawyers were there when Mr. Steele and Mr. Adams came up to you an hour after the meeting and asked you about it? How many lawyers were there?
3, I think.
Okay. Do you recall seeing Mr. Sharp? Just throwing out names.
At some point.
Okay. So Mr. Sharp, Mr. Steele, and Mr. Adams, within an hour, is that accurate, of the meeting, came to you and talked to you about what happened in the meeting?
I would say yes.
Okay. Other than Mr. Sharp, anybody else you remember?
No.
And when they spoke with you, regardless of how they got it, did they share with you any details from the meeting?
Yes.
And what details did they give to you that they already had before you started talking?
Objection, this is not.
Sustained.
Okay. Last couple of questions, Judge. Ms. Bumpus, When you agreed to represent Mr. Copeland, did you, during the course of the meeting that you had in chambers, did you ask questions of the prosecutors or the judge about what the immunity statute meant or anything like that?
Yes, I asked a lot of questions because I didn't realize until the end of the meeting what was actually going on. That information wasn't given to me.
That's all.
All right, so Ms. Bumpus, you knew to show up for court that Monday because Mr. Melnick had asked you to be stand-in counsel for Mr. Copeland, right?
Yes, Judge.
Okay. Are you representing that Mr. Melnick simply said that and nothing else? He didn't give you any background about what you were walking into?
Well, what I'm representing is I was given specific instructions, and those instructions were I'm standing in for him. If Mr. Copeland chooses to plead the fifth, which I anticipate he will do, then you won't have to do anything else. If he chooses to testify, we have agreed that he's discharging me.
Okay.
And I made that very clear to everybody multiple times that morning that that's what I was here to do.
Okay, but you had no idea that there was an immunity order in place?
No.
Okay. All right. Does anybody from the defense side have follow-up questions for Ms. Bumpus?
I have just a few, Your Honor.
Okay.
In your cross-examination, you said, quote, "She says she is not going to prosecute him for anything other than that one thing," unquote. What is that one thing?
I can't answer that. I can only assume it would be the unaliving of Donovan Thomas, but those are the words that she chose to use.
When you say unaliving of Donovan Thomas, what are you referring to?
I get him being killed.
During cross-examination, Ms. Love asked you about some alleged retaliatory acts. Were those being discussed when Mr. Copeland repeatedly said, "I can claim all of this, I can take all of this"?
Nothing was being discussed.
What do you mean nothing was being discussed when Mr. Copeland said, "I can claim all of this, I can take all of this"?
He said that on his own, and that's kind of how the conversation started.
What was the subject matter being referred to when he said, "I can claim all of this, I can take all of this"?
Donovan Thomas's murder.
Okay. I have no further questions.
Anybody else? While Mr. Steele's making his way up, just so I am clear on this, you're saying that are you saying that in the off-the-record conversation that you, Mr. Copeland, and Ms. Hilton had, that Ms. Hilton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay, all right.
So I guess more of a highly possible situation.
That would be the one thing that
Yes,
could
Judge.
get him in criminal
Yes, Judge.
perjury type trouble. Okay, thank you. Go ahead, Mr. Steele.
Thank you, Your Honor. I just want to do timing or sequencing you were asked about. When you left Judge Glanville's chambers after the entire, not bathroom breaks, after Mr. Copeland was removed from the chambers, et cetera, where did you go, if you remember?
I came and sat right there in the courtroom.
At that point, had you spoken with anybody to alert anyone that there was an ex parte meeting?
No.
Where did next time you saw Mr. Copeland was when? When you left the ex parte meeting, came into the courtroom?
Up here. He was up here.
Testifying where you're sitting?
Yes.
Okay. And then did the jury come in?
Yes.
And did Mr. Copeland testify before the jury?
Yes.
At any time during that moment when Mr. Copeland's testifying in front of the jury, did you tell anybody about this ex parte meeting that you attended
No.
or the contents?
No.
Okay. Remember there being a break at any point for lunch?
Yes.
Is that the first time that you were approached?
Yes,
Ex parte meeting?
yes,
True?
yes,
Did anybody, and that's after you were under no restraint, you told the truth?
yes,
And that was to myself and the other people you told?
yes,
True?
yes.
Thank you. Thank you, Your Honor.
All right. Mr. Sharp?
Can I ask one more question?
Sure.
After the lunch break, do you remember when I raised it before Judge Glanville?
Yes,
Did I do it right away after we spoke?
yes,
First time the court reconvened?
yes.
Thank you.
All right, and Mr. Sharp, coming up, and speaking of a lunch break, we're way past time for hours, so let's plan to do lunch right after we wrap up this witness.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes,
Okay, did you hear the Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
no,
Did you hear anyone from the state tell the defense on the record that an ex parte meeting had occurred?
no,
Was there any discussion about the substance of said meeting?
no.
Okay, thank you.
Anybody else? All right, thank you, Ms. Bumpus. You are excused. Let's take our lunch break. Let's come back. It's 20 till 1 right now. Let's come back at 2. Just for my knowledge, does anybody on the defense team have any other witnesses as to this issue?
Not from Mr. Kendrick.
All right. Is the state going to have anybody?
If the court could just, I'm sorry for being obtuse, which exact issue is it that we are addressing? I know it's the June 10th, but what exactly are we addressing? So I can have.
I mean, the defense maintains that there was an unrecorded portion of this ex parte where Brady information was revealed to Ms. Hilton that Ms. Hilton did not then share. So that's our topic. Sure.
What's up, everybody? What a morning. You know, I was not expecting the judge to just get into all that. I don't think that went well for the defense in that. Is anyone convinced that this conversation about Nutt's murder actually happened, that there was an off the record discussion? I mean, they have not fleshed that out very well. Kayla Bumpus was quite a witness up there, but I'm liking it. Yeah, Hugh Mann says Woody knew what he was doing when he fired her, for sure. But, you know, the judge obviously just understands. I mean, she's going to issue a ruling on this, and they say they have witness testimony. I mean, why not hear it? I was surprised she let it go on for so long, especially the stuff this morning about Jonathan Melnick's, professional responsibilities and whether he was colluding with the defense and stuff. I mean, they went over that for a long time. Whereas this thing about whether there's a secret part of the ex parte meeting that wasn't recorded in the transcript, that's a really serious issue. I mean, if it turns out to be true, if the judge somehow believes that, she could throw out the whole case. That would be a huge Brady violation, prosecutorial misconduct. But it's just, I mean, has it come out that way? Their only person who can testify to any of this stuff is Kayla Bumpus. And I don't think this whole show of Kayla Bumpus being on the stand is really helping the defense refute prosecution's concerns that Kayla Bumpus was not the best attorney for Woody. I mean, she has ties to Young Thug. I guess I've heard rumors that she's a godmother of one of Young Thug's kids. Thugger Daly has said that's true. But, you know, the prosecutors expressed a concern, said that she was in court trying to hug Young Thug a while ago. So the idea that, you know, she's there representing Woody, who Brian Steele is openly accused of murder, and said that, you know, Woody's basically getting away with murder right now. It's just, I don't know. It's crazy. But I think the judge is we're going to hear from the judge about what she thinks about all this. I mean, I don't know if she's going to do a ruling later today or like orally, or if she's going to issue an written ruling or what, but we're definitely going to be hearing from them. So Shonda is like, everybody hit me a like, give me a like if you can, let everybody know that we're here. We've got a bunch of people here. Oh, somebody says, and people are so sensitive, just say killing. I think when she says unalive, like she's kind of using like a social media like slang term, you know? Yeah, somebody says, based on what I heard, Kayla Bumpus should never represent anyone in court. I mean, yeah, the idea that is like a, you know, solid criminal defense attorney. But I don't know. It's going to be interesting to see what the judge says, because it doesn't sound like the judge has been too impressed with her testimony so far. So I've got a few clips to post on YouTube. If you guys go to the video section on my channel, I try to update the playlist and everything too, but I'm updating everything in clips. I got to get Kayla's testimony up, but I'm going to do some TikTok clips here soon. So I was going to go over to a sentencing in LA federal court. I had mentioned earlier, there's somebody, he's being sentenced for some hate crimes. Shot two Jewish guys leaving a synagogue service, but I heard that the sentencing is being delayed. I mean, when this was going on, I was like, I can't just leave right now. I mean, it's supposed to start in 10 minutes, but when I messaged somebody, they said it's going to get continued to a later date. So, I mean, I wouldn't want to leave this for anything, but you know, it gets a little isolating watching this online and just being at my desk all day, whereas I could go over to court and see all these people who know me and talk to people and have like all this human interaction. But it's like, I can't just leave the stream right now when this Kayla Bumpus stuff is going on. So the timing was right for the lunch break, but I'm not going to go over there because I heard that there's not actually going to be a sentencing today. It's going to get continued. So I am going to get some more clips up online, and they are back at 2 p.m. So 11 a.m. Maybe I'll go get a coffee or something in the next hour. But yeah, what a crazy morning. And we have not heard the judge's official ruling on all this. You know, was there a secret ex parte we don't know about? But I mean, come on, if you guys were watching the hearing, like this is not like going to end well for them, you know. But and that's what I think is interesting, because I saw people in the comments saying, you know, Steele, give it up. It's like, Steele is so smart. I mean, there's no way he doesn't know how this looks, but he's so genuine about everything, you know. It's interesting. But yeah, I'm looking forward to seeing the judge's official ruling on this Kayla Bumpus testimony and whether she makes any determinations about Kayla Bumpus's credibility. But thank you guys all for tuning in. Hit the like button if you can. Give me a subscribe. Give me a share. And somebody was saying they need to hear from Hilton. And Hilton it's been said that she's going to be out of town this week. I don't think we should assume she's on vacation too, because she seems like the kind of type who would just cancel a vacation if she could. I mean, she probably wouldn't even take a vacation during this trial, but the idea that she just like went to the Bahamas or something that's like hanging out for a week, she would have canceled something like that. She probably has some kind of other professional obligation that she needs to do. But I don't know. So the idea that she can just testify to refute all this, but the idea that the judge like thinks she needs to hear from her, like the testimony is not, it's just not adding up. You know, I mean, the judge isn't being persuaded by this. So, but yeah, YSL Bumpus, is she done testifying? I think so. I think that was the very end. They're like, we're all done with questioning. Okay, we're gonna. And then she asked before lunch, like, are there any other witnesses on this? So that was brutal for her. And somebody mentioned in the comments, especially when the judge started talking to her about her professional responsibilities and stuff. She needs a lawyer. Like, yeah, she does. I mean, the defense attorneys are representing their clients. So of course they're just going to, oh yeah, go up there and testify. It's like, Kayla Bumpus might be kind of digging herself into a hole here, but we'll see. We'll see. Yeah, Dee, you're welcome. It was a wild morning. I'm glad I'm able to do the stream for you guys. Got a few people tuning in. Unfortunately, I'm not just going to talk the entire lunch. And it's kind of tempting to play maybe some old clips, but I know that gets confusing to people when they are looking around and they come in, they're like, wait, is this live or old, you know? So, so I'm just going to go back to the state seal. But again, if you guys go to the channel and check out my most recent videos, I'm going to be doing clips from everything. So anyway, thank you guys all for tuning in. Hope you guys are able to go get some coffee, have some lunch, or enjoy your work or something, but I'll check back in later on.
No, he's not. Ms. Bach.
Well, in the meantime, one thing we can do that is not anything of substance that is important is I want everybody to speak into your mic and let's make sure each of them works all not at the same time, one at a time. And if there are any that don't work, I'm going to try to see if we can get a hold of what it does. So can we start with the state?
Yes, Sean.
All right. And I also am going to try to get a longer neck on each of these, which might help. But for the meantime, let's just see if it works at all. Mr. Weinstein.
Good afternoon, Your Honor.
Does that help at all? Did y'all? I don't know that yours works. Pull it towards you some more.
Good afternoon.
All right. Yeah, you're just going to have to get it closer.
User
to you.
error, I think, on my part.
User error. Okay.
Good afternoon, Your Honor.
Okay. Mr. Steele, does yours work?
Your Honor, is that helpful?
I think we've all got to get closer to them. And I can hear, but I've heard that other people can't hear. So
Is that okay?
that's great. Mr. Sharp.
Testing, Your Honor.
Great. And then who else is left? Misty Williams.
Good afternoon, Your Honor.
All right. Wonderful.
Good afternoon, Your Honor.
Awesome. Thank you. Okay. All right. And now we have somebody here for everybody as well. So let me cross-check mics off my list. Okay. Ms. Love, was there any evidence you wanted to present or any witness you wanted to call with regard to our morning proceedings?
Your Honor, given the scope of what the court has already told us that we were looking into, I don't have any witnesses based on Ms. Bumpus's testimony. And my understanding is that it was Brady material disclosed during the June 10th, 2024 hearing in chambers.
Correct. And what she alleges was disclosed is that Mr. Copeland said, I know more about the infinity and it has to do with somebody that's not on trial. I'm paraphrasing, but.
And so the fact that.
Hang on a second.
Yes.
Yes, sir, Mr. Weinstein, you
I'm
think
sorry.
there's more to it?
I didn't mean to give you side eye, Your Honor. I do believe that there was more that she said that was disclosed other than just the infinity.
Okay, what else?
Specifically when she said that the state would not prosecute Mr. Copeland for lying except for that one thing, which she said was the murder of Donovan Thomas. I believe that was on the redirect at the very end. That actually came through more clearly than I think anything else, Your Honor.
Okay,
Yeah.
so.
May I respond to that? So because that did not, in my mind, amount to Brady, if the court is inquiring into a different issue of.
Hang on just a second. Everybody who's got a phone on you, make sure it is on silent. And you should only have a phone on you if you are an attorney or if you have a Rule 22 that permits you to have a phone. Anybody else in here should not have a phone on them at all. If you do, it should be turned completely off.
I'm sorry, Your Honor, that was my computer.
Okay, it
apologize.
happened.
I
Oh, your
silenced it.
computer? Okay.
I silenced it.
All right, thank you. So, Ms. Love.
I was just saying that based on the parameters that the court set forth, my understanding was that anything that is alleged to have been said by Ms. Hilton in that regard does not impact whether or not Brady material was disclosed. And I'd have a different argument at the appropriate time that the court tells me is the right time to make it. But my position would be that given that defense attorneys came to Ms. Bumpus within an hour of the meeting before court went back in session and asked her, so they had information, they had, I assume, the content of whatever it is that they are alleging took place. And then Ms. Bumpus, based on what I heard her say, told them, sort of filled in the blanks, I'm using my words, not hers, and gave to them this information, my understanding of what Brady is that it is information that is not available to them by any other reasonable means. And they have, obviously, they had someone telling them something about what was going on. So it's not a Brady violation if they had access to it. If there's a different argument, a different issue that we're going to be arguing, I'll hear that from the court. But as to the Brady violation, my argument is that based on her testimony, there was no Brady violation.
Let me add this, Your Honor, too, if I may. Also, the testimony of Mr. in the off-the-record meeting where Mr. Copeland.
The alleged off-the-record meeting.
The alleged off-the-record meeting with Mr. Copeland, to which Ms. Bumpus testified to, where Mr. Copeland allegedly said, I can claim all of this, I can take all of this over and over again, and the all of this was regarding the unliving, the murder of Donovan Thomas. I would submit that Mr. Copeland allegedly saying, I can claim all of this, I can take all of this, would also be Brady material.
And Your Honor, again, given that Ms. Bumpus is the person testifying about it today, and that Ms. Bumpus is the person that was approached by members of the defense within an hour of the meeting, that assertion made by her, though I don't agree with counsel's characterization of it, is information that is available to them. But more importantly, Your Honor, I asked Ms. Bumpus specifically what was asked right before. What she said, she understood it to mean Donovan Thomas. But I can claim all of this. My position is that it's not Brady. I can say I can claim it all too. But a hypothetical, I can. What you can do is not saying something that is.
All right, I understand your argument. So just for clarification, you said I had set parameters as to what is and isn't Brady, and
No.
I haven't set any parameters as to what is and isn't Brady. Brady is what Brady is.
I agree. No, I'm saying the parameters that I was speaking of was that you were talking about. This hearing is about whether Brady material was disclosed. And my position was that what Ms. Hilton is alleged by Ms. Bumpus to have said to Mr. Copeland would not, I don't think it would amount to Brady, but if it did, I can put up a witness about it. I just didn't think that it was necessary unless the court saw it differently than I did.
So I guess what I wanted to have us look into is whether what was alleged to have occurred, i.e. an off-the-record conversation that included, or that was between Ms. Bumpus, Mr. Copeland, and Ms. Hilton occurred, and then if so, what the substance of it was and whether it contained any Brady. So if you don't want to dispute whether it occurred, that's up to you. I'm not going to tell you how to run your case, but I think that's a part of the inquiry as well. So I don't want to mislead you about that. So if you have any evidence that you want to present to dispute whether it occurred or to give us some more, shed some more light on that subject, you're welcome to do that as well.
State calls Deputy Chief Investigator Antonio Long.
All right.
Your Honor, can I make a statement before or while Investigator Long is taking the witness stand? I am specifically objecting to the proffer of Ms. Love, always. But in addition, Ms. Love said that me and other people who represent people, God forbid, accused of these acts, knew already about the ex parte meeting and what occurred and the contents therein, and that is just false. That is just false. That was not testified to by Ms. Bumpus. What she said was they knew that a meeting occurred. No one said contents.
Actually, my recollection is that I asked her specifically that question. Did you share the off the record portions as well, and that she said, yes, she did.
I agree with that. Ms. Love said that before meeting with Ms. Bumpets, that me and other lawyers or people on the defense side knew about what was said at that hearing, and that did not happen.
That's totally irrelevant. So I appreciate it, but I wasn't even accepting that as any kind of a proffer of hers. But yes, so noted, and that's fine. Okay, was there anything else with regard to that? All right. So you said you weren't going to accept a proffer from Miss Love, and that's fine. You said also Miss Long. Do you mean Investigator Long or Miss Hilton, or is there a Miss Long?
Spoke, Miss Love is who I met, but I think because Investigator Long has taken the stand, my mind may have been
All right.
been with him.
Okay. And with regard to just on that topic, the earlier proffer by Miss Love that you objected to, and you said on the record, I don't ever accept any proffer from her. And I said, that's up to the court. I meant it's up to the court whether I want to hear it or not. But with regard to that, and that was about Mr. Abate, my ruling with regard to that was that's not even relevant until which point there might be some other defense motion filed, at which point Ms. Love can call Mr. Abate. So, okay, so call Investigator Long. Thank you.
Raise your right hand. You swear for the testimony to give the truth, the whole truth, nothing but the truth.
Antonio Long, Antonio, last name Long, Long.
And Your Honor, before I begin, I just wanted to point out that I'd like to just make the record. I know that everyone may be familiar with Deputy Chief Long, but I'd like to ask the preliminary questions that establish who he is and where he works, with the court's permission.
Okay, that's fine, but he's going to be testifying as an expert, so let's just, cut to the chase. To the extent he's not going to be testifying as an expert right now. He's going to be a fact witness.
Yes.
Okay.
Yes.
So maybe we don't need to go through all of his background. All right.
Just good afternoon, Deputy Chief Long. Would you tell the court for the record where it is that you work?
I work for the Fulton County District Attorney's Office.
In what capacity?
Deputy Chief Investigator.
As Deputy Chief Investigator, are you over any particular units?
I am.
All right. Are you over the unit that is prosecuting this case that we are here in trial on?
I am.
And as part of your responsibilities as Deputy Chief Investigator, do you accompany attorneys to meetings with witnesses or other attorneys?
Yes, I do.
Specifically, are you tasked with accompanying Deputy District Attorney Hilton and myself when the needs arise?
And among other attorneys, yes.
On June the 10th, 2024, do you recall that date?
I do.
And did you accompany myself or Ms. Hilton to the chambers of Chief Judge Glanville on that day?
I was with Ms. Hilton.
Was there anyone accompanying me? As
Yes.
And was that person one of the lieutenants with the DA's office?
That is correct.
While as Deputy Chief Investigator, do you give instruction to lieutenants and investigators regarding how they are to keep the lawyers in mind and keep their eyes on the lawyers?
Yes, I do. I give guidance and counsel in reference to that.
And are you all required to remain with us at all times during those types of meetings?
Yes.
June 10th of 2024, do you recall who was present in the judge's chambers at the time you arrived with Ms. Hilton?
I do recall Judge being present, court reporter, Ms. Kayla Bumpus, several deputies, and with Kenneth Copeland, and myself and Ms. Hilton.
Was I present in chambers at the time you arrived with Ms. Hilton?
Not when Copeland was there, no.
Did I ever come back after Copeland arrived in chambers?
You did not.
Did you remain with Ms. Hilton during the entire time that she remained in chambers?
I remained with her the entire time she was with Ms. Copeland.
Were you present with Ms. Hilton when was Ms. Bumpus in the room during the entire time that Ms. Hilton was in a room with Mr. Copeland?
Yes.
At any time did Ms. Bumpus leave the room and leave Ms. Hilton in the room with Mr. Copeland without his attorney?
No.
Were you present in the courtroom today when Ms. Bumpus testified?
I was.
Did you hear Ms. Bumpus talk about an off-the-record conversation that took place between Ms. Bumpus, Ms. Hilton, and Mr. Copeland?
I did.
Do you recall during the time that you were in chambers with Ms. Hilton, how many times, if any, that you all went off the record?
Make sure I understand your question. How many times do we go off the record?
Yes, and let me back up and ask you this. Were you able to discern when you all were off the record?
Yes.
How?
When the court reporter was not documenting what was being taking place.
Was there ever a time that you all went off the record at either attorney's request? That is either Ms. Bumpus or Ms. Hilton's?
From what I recall, there were times we stepped out of the room so that Ms. Kayla could talk to Mr. Copeland. And then the last time, there was a conversation before we went back on the record.
At any time that you all stepped out of the room so that Ms. Bumpus could speak with Mr. Copeland, did you observe me go into that room?
No.
Now, when you said there was a conversation that took place the last time, would you please tell the court what you're referring to?
The conversation I believe Ms. Bumpus is talking about right before we went back on the record. There was a conversation where Ms. Hilton spoke with Ms. Bumpus and Copeland before the judge and the court reporter went back on the record.
Did that conversation take place following a time when Ms. Hilton exited the room so that Ms. Bumpus could speak to Mr. Copeland? Or was that a time when you all were sitting in the room and you just went off the record?
That was a time where we took a break, and before we came back on break, it happened. If I'm answering your question, if I understand your question.
Did you all, you and Ms. Hilton, did you all leave the room when you say you took a break?
Yes, everybody left the room.
Okay.
Except for Mr. Copeland and the deputies.
Okay. Did Ms. Hilton have any contact with Mr. Copeland during the time that Ms. Bumpus was not in the room?
No.
Were you present when, or do you have any memory of Mr. Copeland saying something akin to, I can claim all of this?
No.
Were you and Ms. Hilton within close proximity, within 2 feet of each other during the entire time that you all were in chambers?
Yes.
Are you able to say whether you all would have been privy to whatever was said? If she heard it, you would have heard it. If you heard it, she would have heard it.
Correct.
Do you recall speaking with Ms. Bumpus and Mr. Copeland about the Donovan Thomas murder?
No.
Generally speaking, starting there, would you tell the court what you recall talking about?
I'm unclear as to when you're talking about. Starting where?
During the time that you were in chambers with Ms. Bumpus, Mr. Copeland, and Ms. Hilton, can you tell the court the topics that you discussed? That not you, but Ms. Hilton and Ms. Bumpus and Mr. Copeland discussed?
The topic at that time, Ms. Hilton just made it clear to Mr. Copeland that she expected him to tell the truth, and that if he was going to get on the stand and claim something that he know he didn't do, then she would be looking at prosecuting him for perjury.
And so I'm clear, is this on the record or off the record that this conversation takes place?
This was off the record just before the judge came back in.
Have you had an opportunity to read the entire transcript of the in-chambers hearing?
I have not.
Do you recall Mr. Copeland making any direct statements about his involvement in the Donovan Thomas murder?
He never mentioned anything about involvement in Donovan Thomas murder.
Do you recall him making any indirect statements or statements that could be construed as an involvement in the Donovan Thomas murder?
No.
Did Ms. Hilton, during her conversations with Ms. Copeland, while you, Ms. Bumpus, Mr. Copeland, Ms. Hilton, the court reporter, not the court reporter and the judge, in other words, during an off-the-record conversation, did Ms. Hilton?
All right, hey, back up. So is it your testimony that there was one brief off-the-record time when Ms. Hilton, Ms. Bumpus, and Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone to use the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there.
She was not in there at the time they were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to
No,
get
she was not in there.
clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in.
Okay.
And then Ms. Hilton did ask, she needed to say something with Kayla and Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in
Mr.
time?
Copeland was in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would.
Seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record, then that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that, where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or we or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements were inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was something blatant, a blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. She wasn't concerned about inconsistencies that she would use impeach. She would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something that you're the one that did something and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it refer to matters that you later discussed on the record as well, or not?
All of it in sense was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
And showing you, for instance, just page 50 of the transcript, line 11. I'm sorry, line 19. If you'll just take a look at it, is that an instance that is similar broadly in nature to the type of the conversation that took place off the record that you were just describing for the court? And by that, I'm talking about where Ms. Hilton is saying that's different, referring to the word purge. And Mr. Copeland says that can get me back in jail. And Ms. Hilton says, yes. And Ms. Hilton in line 24 of page 50 says, it's not what you're saying, what you're saying is not perjury. What you're saying is what we call a prior inconsistent statement, and so forth and so on. Is that the type of conversation that took place off the record?
Objection waiting.
Sustained.
Yeah.
Sustained. Ask a different question.
Yes, Your Honor. During the conversation off the record, did Ms. Hilton endeavor at any time to help Mr. Copeland understand the difference between perjury and purge?
If you remember.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments, any comments that, were the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't her?
Objection, maybe.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
Do you remember anything that Mr. Copeland said in response to what Ms. Hilton said about being able to, if he got up on the stand and admitted something that she could prove he was lying about?
Yeah, is this you asking during the off the record conversation?
Yes.
Okay.
He said he wasn't going to do that.
And what is it that he said he wasn't going to do?
Get on the stand and lie for something he didn't do.
Do you have memory of him asking or saying something about not going to say that he killed Donovan Thomas?
He didn't use that word. He said he wasn't going to take credit or say he did something he didn't do. Yeah.
Do you recall that those words you just spoke were in response to a question about the murder of Donovan?
It wasn't a question specifically about Donovan Thomas. It was a question about him getting on the stand. It was a statement about him getting on the stand and taking credit for something he didn't do.
And broadly, do you recall Ms. Hilton making comments about Donovan Thomas that Mr. Copeland didn't made any comments about?
Other than if he got on the stand and took credit for something or said he did something that he didn't do and we knew he didn't do. That was the only statement she made, and that he said he wasn't going to get on the stand to do that.
Now, do you have any memory of Mr. Copeland, either on the record or off the record, saying anything about a gray infinity that the state, about having information about the infinity that the state doesn't know?
He never said anything about an infinity to me or Ms. Simone, Ms. Hilton.
Did you ever endeavor to find out what he may have told Ms. Bumpus privately? I don't want you to reveal if you heard it. I just want you to know
No.
if you ever endeavored to find out what he may have said to her privately.
No.
And would it,
Go ahead.
would it have stood out in your mind if Copeland had made any kind of inculpatory remarks about the murder of Donovan Thomas?
Almost definitely. If he had made a remark about the murder of Donovan Thomas, then we would initiate investigation. And I would assign one of those lieutenants to assist me with looking into that.
Do you have any memory of any exculpatory remarks Mr. Copeland made about any defendant currently on trial or not on trial regarding the Donovan Thomas murder?
No.
Your Honor, I'm
Go ahead.
ceding the floor.
That's
Okay.
fine.
All right. Does your memory of what took place during any portions of the conversation that were off the record, does your memory align with what you heard Ms. Bumpus testify about regarding off the record conversations?
The restroom break, just the restroom break.
And what about the content of off the record conversations? Does your memory align with what her memory is as she testified about?
Not for the majority of it, no.
Would you tell the court any discrepancies between what you recall and what you heard that she recalls?
The off the record, like I said before, basically Ms. Hilton having the conversation about Mr. Copeland getting on the stand and taking credit or claiming something that he didn't do and that we know he didn't do. That was in just the gist of the off the record conversation before the judge came back in.
And what, if anything, did you hear Ms. Bumpus talk about that you have no memory of whatsoever, or that you can testify in your recollection did not happen?
The incident about the Infinity, him claiming that I can claim all of this. The part about you coming back the second time, that's what stands out to me right now.
And was my absence from the interactions between Ms. Hilton and Mr. Scratch that. Your Honor, that's all the questions.
All right, thank you. Anybody from the defense side have questions for Investigator Wong? Miss Love, do you need a cough drop? Because I actually have some if you need one. Okay.
Please, court.
Okay.
Investigator Long, good afternoon.
Good afternoon.
I want to talk to you specifically about the off the record portion of the meeting on June 10th, 2024, okay?
Okay.
All right, and if I haven't mixed up was off the record versus on the record, just correct me. I'm trying to understand myself, okay?
Yes, sir.
All right. First of all, the off the record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay, and that was before what we're deeming the off the record
That's
conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Hilton, Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms.
Yes.
Hilton. Okay, and that was to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and then ended up stepping back out.
Okay, and so, all right,
Yeah.
thank you.
And you indicated that during this off the record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off the record portion, correct?
No, that's not what I testified to.
Okay, when was that stated?
I don't ever recall her saying that she wouldn't see charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean what she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Yeah. Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this is me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would see perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes,
Okay, and that was out of Ms. Hilton's mouth.
yes.
Okay, so Ms. Hilton specifically during the off the record portion referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr. Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is in that off the record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
It was both.
killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically
Right.
for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas, that case, into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain because he had received use immunity, not to go in and try to claim something that he didn't do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
I don't recall.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
yeah, we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go back
I
on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
How are you, sir?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and highly favored.
Can I ask you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, Rodalius.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection, Rodalius.
I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Do you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Ms. Hilton, I believe. Yeah, because of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to the session? Say one more time.
Ms. Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you, Your Honor.
You're welcome. Anybody else from the defense?
Oh, I have one other question.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
I'll allow it.
Your Honor, I did not represent to the court.
That's fine. It's all right. I'm going to allow the question.
No. If I understand you correctly, they didn't want to tell me not to say anything.
One more time, you spoke very fast.
I'm sorry. Was your question, did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you, Your Honor.
Mr. Matthews. While Mr. Matthews is making his way over, what is your recollection as to sort of when during the meeting, like within the first 10 minutes, within the last 10 minutes, right in the middle, if you recall that the bathroom break and then short off the record conversation occurred that you testified to?
This was near the end.
Near the end?
Near
Okay.
the end.
All right.
Good afternoon. How are you today?
Mr. Mathis, how you doing?
Doing well, thank you. Just a couple of questions. Did you have any recording devices in the meeting yourself?
No.
Did you make any written notes of any of the meeting yourself?
No.
Okay. And just for the record for today, you were actually in the courtroom during the time that Kayla Bumpus was testifying before this honorable court, correct?
That's correct.
Okay. Did you know this morning before court that you might be testifying about this matter today?
I did not know.
Okay.
I could ponder, but I did not know.
Okay. All right. That's all I have. Thank you.
All right. Anybody else? Any redirect?
When you spoke about the comment that Ms. Hilton made about claiming something that he didn't do, or the Donovan Thomas murder, did she qualify her comments in any way?
What do you mean by qualifying?
Did I hear, did she tack on anything about if she could or couldn't prove it? Or did she just say, if you do this, I will charge you with perjury?
She consistently, if she's mentioned charge, she would say that she would have to corroborate anything before we charge. But she did mention the fact of I can only speculate, I was use the word, the concern about him trying to take claim for something after receiving free use immunity.
And were those comments that she made that you're talking about also accompanied by any kind of explanation, like if I can prove it, or?
Yeah, because she mentioned the fact of if we knew, and we know you didn't do it. Yeah.
Thank you.
Mhm.
Thank you.
Anything else from the defense? All right, is the transcript before the witness at this point? I don't know where it went to.
Yes, Your Honor.
Okay, can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of line, or the rest of page 41? Let me know when you're done.
Okay. I'm done, Your Honor.
All right, is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay, and does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second. Let me look a little past just to make sure.
Sure.
It happened after.
Okay. If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I would.
And I mean, you may or might not be able to, but if you can, let me know. If you can't, let me know that as well.
Your Honor, I believe page 52.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14,
Okay.
when we come back in. Let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so, is that right? Okay.
Right.
And then at line 14, the court remarks, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah, because
So it's right before that the off-the-record
Yes.
conversation occurred? Okay, thank you. All right, any other questions by any counsel? Defense counsel? All right, anybody else? Silence equals none. Okay, Ms. Love, anything?
Yes, Your Honor, thank you. Chief, Deputy Chief Long, on page 40, lines 20 through 25, when the court refers to comments made to Mr. Copeland earlier by Ms. Love, did you ever hear those types of comments made by Ms. Hilton?
Yeah, Ms. Hilton. Yeah.
Was there any time you are aware of Chief Deputy Love, myself, would have been in a position to make those comments to Mr. Copeland that morning?
No, not with Copeland in the room. You weren't around at all.
Okay. Thank you, Judge.
Okay. All right, investigator, thank you. You may step down. Any other evidence, Ms. Love?
Not about, no, Your Honor, not at this time.
All right, any rebuttal evidence from anybody on the defense side of the room? All right. Anything y'all want to suggest that this actually means?
So, Your Honor, there's a case that I believe that Mr. Steele has shared with you. I'm trying to get this site right now. Ford Motor Company versus Young, 322 Georgia Appeals, 348. And that case deals, that case, when we've been discussing this in the past, there's been suggestions that if there was judicial misconduct or what we believe is judicial misconduct from this side of the room, or if there was prosecutorial misconduct or what we perceive to be prosecutorial misconduct from this side of the room, that the remedy was with the bar. And that case, the Ford case, indicates to me that Your Honor in the trial court can play an active role in fashioning remedies in the case of judicial misconduct and or prosecutorial misconduct.
I don't know about judicial misconduct. That's not what that case stands for.
Prosecutorial misconduct or lawyer misconduct, I should say.
Violations of the state bar rules.
Yes, and can I go get one thing for myself?
Sure.
So I filed a motion on Friday.
Yes, I worked diligently over the weekend on writing an order with regard to that motion. Haven't gotten to the Brady portion of it yet.
So, and I appreciate that, Your Honor. I appreciate the attention that you've given it. That motion in the beginning lays out things that I've observed, that I've felt have been highly irregular about this case. The point of my inclusion of that in my motion was not to draw extra attention to it or for anyone to feel sorry for me or anything else, because it's really about my client, Mr. Stillwell. But the purpose of it was to try to inform the court, at least from my perspective, and I think the perspective of some of my colleagues, that things have been irregular in this case. And that there are real life consequences and consequences to the trial when we perceive what we believe is the lack of an impartial trial judge and also of prosecutorial misconduct. In this case, from my perspective, we've had with the ex parte communications in themselves, I don't believe that there was a valid reason to initiate the meetings. I believe that the state and members of the state's prosecution team in particular took something very small and jumped to unbelievable conclusions as a way to get their foot in the door of the judge's chambers to have a discussion. And there were at least two discussions that took place. I'm assuming that there was a third discussion, which may have strictly involved the grant of immunity.
All right.
But, right.
I think we cleared that up on Friday because we specifically asked, was there any hearing or any kind of ex parte, anything with regard to getting the order, or was it just the motion being filed? So, right. I mean, I don't have any reason to believe there's yet another one, but.
Right. And you know, there's a potential under the King case that one, if it was just for the purposes of granting immunity, may have been a proper ex parte, but these were not. The substance of these meetings exceeded what is appropriate. They violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under an exception to begin with. Provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the the procedures for laying the foundation for prior inconsistent statements. To say that that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it. And then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
All right. I would prefer that since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? I've got it somewhere.
Okay, yeah, I've got it right here, Your Honor, from Ms. Persifield's email to us.
I've got it. If you've got it at hand, go ahead. But if you don't, I've got it now.
Okay, I'm trying to find out exactly, try to figure out where it was. Okay, paragraph 11,
Go ahead.
I'm sorry.
Paragraph 11.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th, 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I've provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a
Correct.
couple of days ago.
About goading. And the reason I cite those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a deputy district attorney in the office, head of the unit
All right,
that deals.
can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it for
asked,
now. I have it.
you asked where we are right now, and that's from my perspective,
Okay.
that's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, John.
All right.
Thank you.
Okay, and if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate.
Thank you, Your Honor.
And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3. 745 Southeast 22299 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court, and
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2, Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hilton and Ms. Love. And you've inherited a case that has a lot of history and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement, I don't know if you've read it, so.
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Miss Love that was the fourth time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory, but it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm actually disqualified because it's just not, at some point, the message needs to be sent that this is not the state of Georgia and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hilton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to. And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right. Do y'all want to be heard from the state on this? Or do you want to go ahead and present some testimony to counter the Melnick, that you knowingly contacted Mr. Copeland, knowing he was represented by Mr. Melnick?
Absolutely, Your Honor.
All right.
What we did was ask that our witnesses be summoned, if you will.
Okay.
If the court
All
would
right.
just give us.
Sure. Why don't we take a convenience break, and can you let a deputy know when you're ready with somebody, and we'll come back out.
Yes,
Thank you.
thank you.
Appreciate it. Witnesses for the state. Ready? All right, let's get that person on the stand.
John, Adam Abadi.
All right. I remember one time when I was called as a witness in a case for some very ancillary matter, and we're so used to being the ones examining. We're not used to being the witness. And the direct finished it. I got up to leave, just like all of the lay witnesses who have no clue. And then I felt like an idiot. But oh well, maybe Mr. Abadi won't do that. We'll see. You're coming up to the witness stand.
Like Mr. Melnick, I'm an officer of the court. He can swear himself in, like whatever.
All right, let's.
Like Mr. Melnick, I'm an officer of the court. He wasn't sworn in, but yes.
Thank you. Good afternoon, Chief Deputy Abadi. How are you?
Fine, thanks.
Just for the record, would you state where you work and what your position is?
DA's office in Fulton County. I'm the Chief Deputy of the Major Crimes Division.
All right, and February the.
It's ABBATE. And I said Chief Deputy of the Major Crimes Division.
February of 2023, where were you working within the DA's office, if anywhere?
Same position.
All right. During that time, do you recall having a conversation with an attorney by the name of John Melnick regarding a person by the name of Kenneth Copeland?
Yeah, it was a conversation on a Zoom call where Judge Whitaker was on the call and heard all the contents of what I'm about to testify to. Yes.
All right. And would you tell the court what the purpose of that Zoom call and that conversation with Mr. Melnick was?
It was related to a bond order or bond conditions for a bond order for his, I think it's 22 SC 182, I think it'd be 134. It was his possession of a firearm by convicted felon and reckless driving, I think is what it was.
Okay. And did you have occasion to look at the bond order and see its contents, or the proposed bond order? Had the state proposed a bond order?
Yes.
Right. And did the state's proposed bond order have any reference to or any conditions that are related to Mr. Copeland's witness, position as a witness, in this case, 22 SC 183-572?
No, not my recollection specifically, no.
Did the bond order or the proposed bond order reference co-defendants? Let me ask this. Are you familiar with the co-defendants on, or the defendants on indictment 22 SC 183-572?
Some of them, yes. I've tried. I think Khalif Adams was somebody who I was the prosecutor who, when he was convicted of murder.
And the bond order referenced some of the defendants on this case?
I think it referenced all of the defendants on the case involving Jeffery Williams.
All right. Did the bond order, well, Your Honor, I asked the court to take judicial notice of the bond order, which is in this case.
I'll take
already
judicial
filed.
notice of it, but I'm also just going to print it out right now and make it a part of this record, so it'll just be easier.
And I did misspeak and say, in this case, it is actually in Mr. Copeland's 22 SC case.
Yeah, 22 SC 182 134.
Thank you. Would you please tell the court the content of the conversation or communication you had with Mr. Melnick regarding Mr. Copeland on that day?
Yes, it was. So it was me, myself, Abigail Potter, who at the time was the trial division lawyer assigned to Judge Whitaker's courtroom, Judge Whitaker and Mr. Melnick, and I believe Ms. Rosser, the case manager who set up the Zoom link, was on the Zoom, and it was just a discussion as it related to the bond conditions for his possession of a firearm by a convicted felon case that was before Judge Whitaker and the conditions that would be included in it.
Was there any part of that conversation that referenced Mr. Melnick representing Mr. Copeland as a witness in this case?
Yes, specifically, and the reference is that Mr. Melnick was all hot about the fact that I was on the call, representing as a representative, pretty much for you as a member of the team for this case, because he specifically said on more than one occasion that I'm not here about that case. I don't represent him on that case. The only case that I have before this judge that I represent Mr. Copeland on is the 22 SC case. He said it over and over again, and he kept making snide remarks related to you and the district attorney's office, and eventually me, to which I said, I finally interrupted him. I said, we're done with your used car salesman, stuff. And that's when the judge was kind enough to intervene and say, all right, whatever, we're here just for the 22 SC case. We understand you don't represent him in the YSL case because there's nothing to represent him on, was the gist in my recollection.
When you're talking about the 22 SC case, are you solely meaning the one Mr. Copeland faced charges on, criminal charges on?
Yes, the one that was before Judge Whitaker that we were there for to, negotiate and agree upon bond conditions for. I think it's 22 SC 182, I think it's 134. And the charges were possession of a firearm by a convicted felon and I think reckless driving. I think this all happened February 24th of 2023.
Do you know whether that Zoom call was transcribed or whether or not there was a court reporter on that Zoom call?
I'm not sure, but I don't remember seeing, I think it was Miss Evelyn, sorry, who was the court reporter back then. I don't recall.
Do you recall how many times Mr. Melnick stated with any degree of emphasis that he did not and was not representing Mr. Copeland in his capacity as a witness in 22 SC 18357?
2 or 3 times, and it was all in relation to the state's request that he be fitted with an ankle monitor. And that was particularly angersome, I guess the correct word, as it relates to Mr. Melnick's reaction, because that's when he kept saying, this case has nothing to do with that case. I have nothing to do with that case. I don't see why he has to have an ankle monitor.
Are you familiar with what it is that the state was trying to secure with ankle monitor?
His location at all times, I suppose.
And are you familiar with Did you speak with Mr. Melnick at any other time regarding his representation of Mr. Copeland as a witness in this case?
No, I tried to avoid him as much as possible.
Has he ever in life represented to you that he represents Kenneth Copeland as a witness in this case?
No, it was the exact opposite in front of the exact same judge that we're sitting before today.
And showing what our market states is it's true. I don't know if the court had already-
Here you go. Here's the bond order.
Showing you State's Exhibit 2, which I'll mark, which is a copy of the filed bond order. Is that the bond order that you spoke with Mr. Melnick about on the date that you're speaking about now? Or is there?
So this would be the bond order that came from the conversation we had in February, I think February 24th of 2023. This is this is stamped for March 3rd, so there would have, the whole reason for the Zoom was to negotiate and come to some sort of agreed upon set of bond conditions as it related to Mr. Copeland and being released on bond for the 22 SC 182134. Okay. So this would have been the product of that conversation.
Okay, thank you. All right, that's all that I have with this witness, Your Honor, for right now.
All right, any questions by any of the defense attorneys for this witness? Nope. Ms. Weinstein, Mr. Matthews?
No, Your Honor.
Mr. Harvey, who I can't really see over there in the corner. Is he even there? Is Mr. Harvey over there? Anybody for Mr. Harvey's client? Any questions? Okay, great. Thank you for your time. You may step down. All right, call your next witness.
State call Attorney Peter Herzog.
Okay. It doesn't matter to me. I mean, do you want him sworn or do you want him to testify in his place?
I'll have him sworn in.
All right, yes, please swear him.
Raise your right hand. Swear firm testimony you give the truth, you tell the truth, the whole truth, nothing but the truth.
I do.
Have a seat. First, second, of course.
Peter, Peter, Herzog, Hertzog. TZOG.
Good afternoon, Mr. Herzog.
Good afternoon.
Would you please, just for the record, state for the court, where is it you work and what position you hold there?
So I'm a senior assistant district attorney in the anti-corruption unit of the Fulton County District Attorney's Office.
How long have you worked in the anti-corruption?
Since I started in the office, about a year. I think I started March of 2023.
Did you say March? And I just need to speak up a little bit louder. March 2023?
Yeah, I think it was March. I've been here about a year and a half.
Have you ever worked in any unit besides the anti-corruption?
I did a short stint where I screened cases and then I cover a court part for a complex. I've always remained in anti-corruption.
As an attorney with the anti-corruption unit, have you ever had an occasion to speak with Mr. John Melnick about a person by the name of Kenneth?
Yes, I believe so.
At any time during those conversations, did you ever, in any way, seek any information regarding Mr. Melnick's representation of Kenneth Copeland as a witness in the case 22 SC 183572?
No.
Did you ever, in any of those conversations, have any occasion to talk with Mr. Melnick about his representation of Kenneth Copeland as a witness in any YSL related case?
No.
Did you ever, during your conversations with Mr. Melnick, reference either myself or Deputy District Attorney Simone Hilton?
No, not to my recollection. No.
Have you ever been asked by either of us or anyone prosecuting the YSL case to reach out to Mr. Melnick?
No, absolutely not.
Is this the longest you and I have ever even talked?
I believe so. I think I ran into you once in the hallway and said hello. Other than that, I don't think we had much contact.
Did the matter that you spoke with Mr. Melnick about have anything to do, in any tangential, direct, indirect, any way, have anything to do with 22 SC 183572 or the criminal indictment that preceded it?
Absolutely not. No.
Was the case that you spoke with Mr. Melnick about a case that was in your unit?
Yes, ma'am.
Were you ever asked by anybody in the DA's office to have any communication with Mr. Melnick regarding his representation of Kenneth Copeland as a witness in this case?
No, ma'am.
Did Mr. Melnick ever just tell you, hey, I'm representing Kenneth Copeland as a witness in the YSL?
No, not to my recollection.
Do you recall sending Mr. Melnick an email back in March of 2023?
March of 2023. I don't recall.
Yeah, I'm not certain exactly where the evidence.
I'm sure it's somewhere with the court order.
I'm going to show you what has already been admitted as defendant Williams number 4, Your Honor. And I'm going to show you ask you to take a look at the bottom portion of defendant Williams number 4. Ask you if you recognize or if you recognize that time frame as a time frame that you reached out to Mr. Melnick.
I did reach out to Mr. Melnick. It could have potentially been around that time frame. If you, I can go into more detail.
Yes, please.
So we were investigating as part of anti-corruption. We were investigating.
Without getting into the details of any anti-corruption case
Okay.
at all.
There was an allegation made that involved Mr. Copeland. At the time, I was relatively new to the office. I'm not from here. I'm from New York. I spent years practicing up there. So I know nothing about what's going on down here in relation to this case. I reached out to Mr. Melnick to see, as per our usual in our unit, to speak with every witness. And I believe I asked him if Mr. Copeland wanted to talk about that specific matter, and don't believe we ever followed up on it.
Was Mr. Copeland in jail at the time that you reached out to Mr. Melnick?
I believe so.
So was Mr. When you reached out to Mr. Melnick, where and why did you seek to go through Mr. Melnick to get to Mr. Copeland?
Because if I remember correctly, he represented Mr. Copeland in that other matter.
To your knowledge, had that other matter been resolved?
At the time, I'm not sure if it was resolved at that time. I don't believe so. I think that's why I went through Mr. Melnick, I believe.
Outside of the anti-corruption matter, did you speak to Mr. Melnick regarding anything else related to Mr. Copeland?
No, ma'am.
That's all I have.
All right. Any defense examination of this witness?
You know, I did a thing, I wrote a check mark. I don't have to get that out.
Okay, probably have some white on it, if that would work. That I think with everybody on it's for Miss Love White felt the check mark she inadvertently wrote on states 4, which is why I don't like to ever handle the evidence, because I'm constantly taking notes and I end up writing on the evidence.
And it's Williams exhibit.
Is that okay? All right. Thank you.
With the court's permission, I'll do it after Mr. Sharp has had an opportunity.
Go ahead, Mr. Sharp.
Good afternoon.
So from what I understand, March 2023, you are working for the DA's office in the anti-corruption.
Correct.
Okay, and you are building up a case?
Yes. I'm investigating a case. I'm building up a case. I'm investigating a case.
And is Mr. Copeland the target of this case?
No.
Okay, so he's a witness.
Yes, he would have been a witness.
He's a fact witness, I assume?
Objection, Your Honor, to the relevance of what type of witnesses.
Sustained.
What kind of case is this?
Objection as to the.
Well, can we just leave this an anti-corruption type case?
I ask, was Mr. Copeland the victim?
No.
So he's a witness.
Well, it's
Yes. Do we need a bench conference? Okay. The earphones work right now. So what I'm wondering is if y'all would be comfortable with Mr. Sharp relaying the substance of bench conference, or if each of you wants to try to come up and gather around, or.
And Your Honor, since we cannot have, since we don't have the ability to let it be heard, I'd ask that the court ask whether each defendant waives their presence at the bench conference.
So do the attorneys want to come up, or? Okay, so I know the defendants normally are able to hear what's going on. I'm sorry we're having technical difficulties. Apparently need to put these things on their charger pretty frequently in order for them to work. So I'll know that for the next time. But one of your attorneys is going to come up and listen to what the substance of the bench conference is, and then I am directing them to return to the tables and let you all know what we talked about. I want to find out whether that's okay with each of you defendants. And also, I am happy if you're not satisfied with what the attorney has told you about it, then you can let me know and I can say, well, here's my take on what happened. Okay. So, Mr. Kendrick, are you okay with Mr. Weinstein just coming up and then telling you what we talked about? All right. How about you, Mr. Huey? All right. Thank you. Mr. Williams. Okay. Who else do we have? Mr. Stillwell, you okay with that? All right. And then Mr. Ryan, you okay with that? All right. Thank you. Appreciate it. So y'all kidding?
Yes, Your Honor.
And do any of the defendants have any questions about it that they want to ask me? Okay. And did you talk to your client about it?
I will.
Do you? Okay. All right, go ahead.
Attorney Herzog,
Spin your mic towards you.
the anti-corruption case that you were working on in March 2023, is that still an active investigation?
No, it is not an active investigation. It was and the investigation was wholly unrelated to YSL.
Okay, and is there a pending case involving that investigation that resulted from that investigation?
A pending criminal case?
Yes.
No.
Now, at the time you sent this email, you wanted to speak with Mr. Copeland, correct? About the matters you were working on.
Yes.
Okay. And you have the ability as a district attorney, you said that your understanding is he was in jail, correct?
I believe so.
Okay, and you have the ability to go to the jail at 901 Rice Street, correct?
Yes, I have the ability to go to the jail.
Okay, and as a district attorney, you have the ability to bring an investigator with you and interview a witness there, correct?
I wouldn't represent someone I wouldn't speak with someone that was represented by counsel
Okay,
on any case or was recently represented by counsel.
okay, so the reason that you called Mr. Melnick is because you would not speak ethically. Your code of ethics, you would not want to speak to someone who's represented, correct?
It's all of our code of ethics.
Correct. And you also would not want to speak to someone who was represented recently. Is that what you said?
I would reach out to the defense attorney prior to that, yes.
And that's what you did in this case. You reached out to Mr. Melnick, correct?
Regarding our investigation, and
Understand.
the scope to our investigation.
Yeah, I understand. You were not involved in the YSL investigation, correct?
Correct.
Okay. But as part of your investigation, you reached out to Mr. Melnick in an effort to speak to his client, Mr. Copeland, correct?
Yes, I believe so.
I have no further questions. Thank you.
Does anybody else have questions for Mr. Herzog? All right. No?
Inquiry for the court.
Sure.
I don't understand enough about it, and I understand that the ruling is maybe I shouldn't know about it. With the court, Mr. Williams has no objection, and if you do, please correct me. Would the court be able to find out whether this has any Brady implications from Mr. Copeland, either under Giglio getting a deal, or he did not get prosecuted because he was involved, but he was being used as a witness, and I don't have that information.
Sure, I don't either, but yeah, that's valid. Let's find that out. So you can ask that question. You don't have any objection to that question, do you, from the state? Okay.
Hello.
Mr. Still.
Brady evidence, you feel comfortable talking about Brady evidence, what is required by Brady and its progeny?
Is this the question of whether I feel comfortable?
Yeah, do you understand Brady and its progeny, what it includes?
Yes.
Okay, and I didn't mean that to be insulting at all, just, some people have different definitions of something. Dealing with Mr. Copeland, only Mr. Copeland, was there any type, no matter how non-promising, was there any type of agreement, promise, benefit to him, whether that's reduced charges, no charges, he's cooperating, he's a CI or whatever you want to call it, anything to do with that?
Absolutely not. I have no information regarding the YSL case or any investigation of the YSL case. I reached out solely related to a wholly unrelated matter.
Okay, and I'm broadening it besides what you call the YSL case. I'm saying, was Mr. Copeland given any benefit? Forget about this indictment before Honorable Judge Whitaker. Was he given any benefit on any matter, including the matter you were investigating?
Not to my knowledge, no.
Okay, all right, thank you, Your Honor.
Okay. All right, anybody else? Mr. Williams? Okay, anybody? All right. Any redirect by the state? All right, thank you. You may step down.
Thank you, Your Honor.
And did you have one other witness?
Yes.
Are they ready?
I couldn't allow Mr. Atkins to go outside.
Sure. While we're waiting on finding that out, y'all, well, I guess it was Mr. Atkins that was going to do it, so never mind. I'll wait on that one, trying to see what else we can get done while we're waiting. Nothing.
There was one matter, I guess, as it relates to Mr. Copeland, that I would ask that the court take additional notice of, since we're all on here.
What's that?
The date that his criminal matter that we were just introducing testimony about was resolved. There should be within the 22 SC 134, I believe, case in Odyssey, a disposition for those criminal charges. I would ask the court just to take judicial notice of that date.
All right, so it appears that the plea was entered on June 28th, 2023, and the disposition was filed on June 29th, 2023, and I'll take judicial notice of that. All right, what do we know, Mr. Atkins?
So Ms. Potter is 30 minutes away. I'm not going to ask the court to wait on.
Okay,
I'm
okay,
sorry, he said 40 minutes, he corrected.
okay.
And so rather than have the court wait on that,
We're gonna do that tomorrow?
I can, yes, I can do that.
All right.
And Your Honor, the other thing that I was looking at was to obtain a certificate of service for Mr. Copeland that I believe was filed. I think he was served most recently in May of 2024. And if the court would indulge me one moment, I was just trying to determine who it was that served. And since the subject is state's actions regarding a witness, Mr. Copeland. And I would also argue to the court that there is not standing to complain of the interactions between state prosecutors and their witnesses in this case. And there's not standing to complain of what happened as it relates to Kenneth Copeland in the in-chambers hearing. But to the June 10th, in terms of King and its progeny, and what the transcript reflects, and the court has heard testimony reflecting.
All right. Well, their claim is a right to be present, and they have standing to make that claim. Whether I make a determination that they did have a right to be present or didn't is yet to be determined, but they can certainly make the claim. Was there, with regard to them, are there not being standing to complain about whether the state communicated with Mr. Copeland when, according to the defense, the state knew him to be represented? I understand the assertion in that regard to be that the prosecution has violated a bar rule, and that they've also violated other bar rules over the course of this case, and that I should take that into consideration in determining whether and what remedy to fashion. Do I have that about right? I'm getting nodding yeses. Okay. So yeah, they can assert that to the court.
Okay. And Your Honor, as I obtain for the court that, the final two pieces of information.
Okay.
I asked for the court's indulgence for years. The certificate of service and the date that he was served.
Okay.
That it was filed on.
All right, I'm not even sure which one you're talking about, but sure, if it's relevant, I will unseal it. Can you let me know which one it is?
It was a certificate of service and it was filed on. Okay, that's what we're getting today.
Okay. It's, and then case, this YSL case?
Yes.
Okay. So I actually, once you let me know what it is, I actually, because I'm the court and I can, kept a copy of what is in each of the sealed filings once I reviewed it, so that in case we needed to see something again, I didn't have to do another order unsealing and resealing. So those are in an envelope in my litigation manager's office. And when you let me know what it is I'm looking for, I'll just pull it out of there.
There is a certificate of service for Kenneth Copeland that should have been reflective of a subpoena that was served on him, I think in May of 2024.
Okay. Without
The exact date, I don't want to, I think maybe May 31st.
Okay.
That sounds about right. May
All right.
31st of 2024.
Sure. And maybe Ms. Persfield, you already are anticipating my need and sending an email to Ms. Rosser to see if she can pull that. Thank you. All right. And then with regard to Ms. Potter, is she gonna be available in the morning, or does she want to Zoom? I don't care if we take her testimony by Zoom if nobody else does.
Okay.
I don't even know if she's available, but that's an option as well.
Thank you, Judge. That would actually work. I'm gonna,
All right, would that be okay if, I don't know if everybody's familiar with Ms. Potter, but I don't know if is she still with the DA's office?
she is, she's just
Okay.
outside.
She's a prosecutor with the DA's office who used to be in my courtroom and who was the prosecutor for the case that Mr. Melnick handled on the other side of. Would everybody be okay on the defense side with us taking her testimony by Zoom here in court? If anybody has an objection, please voice it orally now. Okay. All right, so that'll work. If you can line her up for that, and I think you already have the Zoom link, we can do that.
Thank you.
All right. And as Ms. Love's doing that, Mr. Atkins and whomever from this side of the courtroom was going to work on the maybe one or two issues with Mr. Copeland's jail calls over the weekend. Did y'all get an opportunity to do that and reach any kind of resolution?
Your Honor, I have not spoken with any defense counsel in relation to those jail calls.
Okay. Wasn't that your task?
Your Honor, I will speak with Mr. Shard.
Okay. I can't remember who said they were going to do that, but I don't know. Y'all had told me at the end of Friday, before we had all of our more explosive motions put before the court, that on the jail calls that might or might not come in with Mr. Copeland's testimony, y'all had maybe two items that you thought you could work out everything, and there were two items that were still kind of in dispute.
That may have been Ms. Fulton.
It might have been, I don't know.
I was out a little bit on Friday, but did Mr. Steele not deal with the jail calls at the end of the day on Friday?
I mean, so what we ended up doing was saying, oh, we may be able to just come to agreement on everything. So give us a little minute over the weekend and we'll get back to you. Anyway, apparently nobody did it, but y'all do that
Yes, Your Honor.
tonight, if possible.
Yes, Your Honor.
Your Honor, may I be allowed to step outside the courtroom for a brief 5 or 7 minutes?
To line up Ms. Potter.
To line up Ms. Potter, and to speak with another member of our office.
Okay, so we will take another break and be back whenever you let a deputy know that you're ready. Okay, which hopefully won't be more than 10 minutes. All right. All right, were you able to get Ms. Potter?
So Judge, my request is that the court allow us, if I call her, to do it in the morning, and to also allow us to, because we've got the case that.
Hang on.
We're missing some defendants.
Oh.
Sorry, they said we're ready. So I just kind of assumed we were ready. Hang on. I should have looked. There are some empty chairs. That's everybody all right?
Thank you, Judge. The state is asking if the court will allow us an opportunity to respond to the Ford Motor Company case that we provided today, and in making our final argument, and to allow us, if we decide the need to call ADA Potter. The main thing that I wanted to get out was regarding when Mr. Copeland pled, and I haven't had an opportunity to talk to her about that. I think she was the one that represented the state in that plea.
Yeah, she was, but I mean, I told you that he pled on June 28th of 2023.
Right. When I first started looking at Abigail Potter and had the three names.
Oh, okay. So you may not need her after all, then that's fine. Yeah, if that's all you needed her for, it's in the court record.
Okay.
And I had taken judicial notice of it. And then a response to the Ford case, I mean, with regard to whether that's the law or not, or whether that's an appropriate
I have not
sanction. Yeah, yeah, sure. You haven't had a chance to take a look at it. Sure. Is that what you're saying?
Yes.
Yes, that's fine. You can make whatever response, if any, you want to in the morning.
And thank you. So that's it.
Okay.
Outside of Ms. Potter, I don't think that we would have any other persons to present, but if we did, we would have them here and ready to go first thing. I just wanted to review all of our notes and make certain that every issue that was raised here today is addressed properly.
That's fine.
Thank you.
And Ms. Rosser's looking for that certificate of service of the subpoena. And
I know that we keep copies, so I can get one of those too.
think that I've got the certificate of service of a subpoena that you are referencing, because it has that on May 31st, Investigator Long actually served Mr. Copeland, and I'll let you look at it, but it looks like it actually is also attached as a, and I don't know if it was or not, but it at least references that the order that Judge Glanville enters on the 7th that is pursuant to 24.5.507 that gives him immunity, maybe attaches that subpoena, but I don't know. Anyway, if you want to come take a look and see whether that's what you mean. And if so, we can make a copy of it and you can do whatever you want with it from there.
Okay.
Is that it?
It is. It's attached to the, as the court said, it's attached to the motion to, well, the order granting the state's motion to compel.
All right. And so it's already, I would think, then in the record.
Yes. Yes.
All right. And so what's their argument you wanted to make about that? Or just
that, and I can reserve the rest of it for tomorrow, but just that he was served, Mr. Copeland was served on May 31st, and I think that's well a week before he was ever called to testify or anyone was informed that he would be the next person up. And we did not, I'll make argument at the appropriate time.
all right. Okay, so tomorrow, in addition to wrapping up whatever final evidence and argument there might be as to either of those issues, what I would like, I think y'all now have, if not every bit of Mr. Copeland's prior testimony, almost every bit of it, and Ms. Weaver's been pretty fast at turning it around. And at this point, it may be best to redo the entirety of Mr. Copeland's testimony, including bringing him back in and asking him whether he wants to testify. And I'll hear from everybody on what we might need to advise him of, if anything he's been, or re-advise him of, or correctly advise him of, and then maybe start from scratch with him. If there are things that everybody can agree, I just don't know whether we know what he's going to do or how he's going to testify. So I don't know if it's productive to continue to look and see whether there are things y'all can agree on. But if there are things that everybody can agree on and we can just say, okay, you know, these 5 things take as, you know, something he said and the rest of it redo, or whether we just want to start 100% from scratch. As I understand it, nobody had played the June 10th, 2015 interview from him yet anyway, right?
That's correct.
Okay, and that's the only one where he inculpates any of these defendants, right?
No.
No, that's not right. That in the Donovan Thomas murder is what I mean.
Oh. That's the first one, yeah.
Okay. All right.
Directly in the way that he did on
Okay.
that.
Okay. All right. But we need to make some progress into I am still considering and working through Mr. Shard's motion, and then we'll get to Mr. Weinstein's motion for mistrial. Both of them are motions for mistrial. But assuming for the purposes of getting things done, that those are not ultimately granted, then we need to pick back up with this trial. Obviously, if they're granted, then that's a whole other ballgame. But I want us to make progress in the meantime. So tomorrow, I would like for our focus to be on how to handle Mr. Copeland and his testimony or potential testimony once we have the jury back, whether there's any agreement as to anything, proposed jury instruction as to if we're disregarding any or all of it, what that should say, whether we need to take notes, all of that kind of like the details we actually need to think through. I want y'all working on that tonight so that we can make progress with that tomorrow. And, there are a lot of things up in the air in this case. And I am going to once again say to everybody that there's a lot of risk for everybody. There's a lot on the line for everybody, both sides of this case. And I know not everybody has necessarily the most fruitful relationship with each other across the aisle right now. But I know, Mr. Steele, you said that you do still have a good relationship with the district attorney herself, who certainly authorized to talk about each and every case because they're all her cases ultimately. But, y'all need to be thinking about all of the potential ways to handle and move forward in this case. And I encourage y'all to be doing that because who knows what it's going to be otherwise, okay?
And Your Honor, we did get last night, speaking of things that we can deal with.
Yeah.
We got last night from Mr. Sharp, and he can correct me if I'm wrong, I believe about 76 proposed redactions from the proffer of one of our witnesses that we discussed on Friday, Mr. Zachary.
Okay.
At some point, I know that the court is going to have us to address those. So, and I believe that Mr. Sharp, he can again correct me if I'm wrong, said that he could go through that was what in the August 2017 interview, a proffer from Mr. Zachary. And there's an earlier one that I think he said he's going to go through and okay. He said he's gonna go through another one.
Okay.
And so if he sends us those, that's another thing that we need to work out.
Perfect. And so y'all go ahead and tackle the first 76, see if there are things that you can agree on so that we can have an efficient day like we did on Friday where we sort out so that everybody knows here's what can and cannot come in potentially with regard to this witness. And he's coming up pretty soon. And if Mr. Copeland makes a decision different than his last decision, we may be getting to Mr. Zachary sooner than we think.
And if that is the case, then the state would have a motion for the court, similar to the one prior, with respect to Mr. Copeland.
You're gonna have to give me a hint as to what you mean by that.
So Your Honor, just now, Your Honor reference, if Mr. Copeland chooses to do something different than what he chose to do last time, with respect to testify, I'm assuming the court needs to plead the fifth again. I don't know.
Well, I mean, I'm not undoing the immunity order. The immunity order stands. Unless y'all got some, I mean.
That's what I understand.
Okay. All right, well, I mean, I guess we can, I don't at this point see a need to undo and potentially redo an immunity order. I know that there is the argument about how paragraph 11 might contain a misrepresentation as to whether there was an encounter. I mean, the way I read it and what it says is there was an encounter with representatives of the DA's office and people from the defense team. After that, Mr. Copeland told somebody he might plead the fifth. Now, I don't know whether from that it means Mr. Copeland was even a part of that encounter, or if that's just given me some kind of a timeline about one thing happened and then another thing happened. But the import of that to the predecessor judge and to any judge considering does immunity need to be granted and is immunity in the public interest here is not what triggered it. It's this witness who the state thought was going to be testifying voluntarily under subpoena or not now intends to take the fifth. The only way we can get their testimony, which we believe we need, is to compel it. Will you compel their testimony? That's the import of it to me, not what led up to it, because there's no allegation of coercion or dirty dealing or anything like that, if it even means that Mr. Copeland was involved in any of that. So I don't believe that the immunity order needs to be redone. If somebody else thinks differently, y'all let me know that right now. Silence. Mr. Steele.
I don't believe anything before Mr. Weinstein filed the first motion to recuse. I'm not challenging anything before that.
Okay.
But I do want to hold, there was a lot of exculpatory information before the recusal motion was filed. So I don't want to wipe out Mr. Copeland's testimony on the 10th,
All right.
11th, or part of the
All right, which is why I need y'all to get together on it and let's tackle that tomorrow. The nitty gritty of it. Okay. All right. So that means y'all have to do that tonight if you haven't already done it. All right. Anything else before we break for the evening? One more thing. All right, so it's my understanding that other than the transcript of June 12th, everybody should at this point have all of the testimony of Mr. Copeland, and the transcript from the 12th should be forthcoming within hours. And, you know, Ms. Weaver was working at like midnight last night. So as soon as she gets it, she'll either forward it to Ms. Percival, who forwarded it to you, or she'll forward it directly. So y'all should have that very shortly. All right, anything else before I bid y'all adieu for the day?
May I inquire if it's appropriate? Is the court's plan to bring the jurors back in on Wednesday? Is that still the plan?
I don't know, because we got things done today, but we didn't get any evidentiary, make any evidentiary progress today. So I don't know. It's less likely now than it was on Friday. And I'll just let y'all know right now that I have an appointment that was set up well before I had any involvement in this case for Friday morning. So I am not available this Friday morning, regardless, this coming Friday morning. And I'm not gonna, I don't know. Let's just see how tomorrow goes. I think we'll have a much better idea tomorrow, whether it's Wednesday for 2 days, which I don't love, or whether it's just next Monday, and let's actually make lots and lots of progress in the next few days and then buckle down with a trial on Monday if it turns out being that. But I'll, remind me tomorrow to think about that again. All right. We're adjourned for the day.